Okay. About only 2:30 to 3?
Yeah.
Great. Good afternoon. This is the House Judiciary Committee. It's the 13th of February, 2025. We have only 6 bills today, everybody, and not as many witnesses as the 130 that we had last night. We're going to start with the bill that has the most witnesses, though. Delegate Crutchfield's bill, House Bill 223. Delegate Crutchfield, go ahead, and we'll hear from everybody here, take questions, and then I'll go to, there are a ton of virtual people testifying, so we'll bounce back and forth. Okay.
All right. Well, thank you, Mr. Chair, and hello, committee. And wow, this is the first time I actually have a bill as the #1 bill today. So I'm excited. There you go. And for the record, I'm Delegate Charlotte Crutchfield. I represent Montgomery County's District 19, and I am here to testify for HB 223. And we are calling it the Know Before You Knock Family Rights to Notice Act. And what we're really doing here is really simple, okay? So what we're trying to make sure is that parents and guardians that actually are approached by DHS because there has been a charge or an investigation started or some kind of other reason that DHS should be knocking on their doors, that the parent and guardian actually knows what's happening, actually understands why they're there, what it means for them to be there, and that they know what they can and cannot do in those situations. It's very, very simple. That's all it is. And as part of that procedure, we will be asking the DHS worker who's actually there, and usually they're there with a law enforcement officer, we'd ask them to provide to that particular parent or guardian an actual notice, a piece of paper that says to them, these are your rights, this is what you can do in this situation, and oh, by the way, you can also call for counsel at any time. That's all this does. So what I'm going to do is I'm going to hand it over to my panel here, who is going to explain it in even more detail. And of course, we will answer any questions, and I hope that you will find a favorable report on this bill. Thank you.
Thank you. Good afternoon, Mr. Chair, Madam Vice Chair, and members of the committee. My name is Nina Villamar, and I'm the Chief of the Parental Defense Division of the Office of the Public Defender. We represent parents in every county in Maryland where the Department of Social Services seeks to remove their children from them or are about to remove their children from them and file a child in need of assistance petition. Right now, we have more than 4,000 cases that are active. And the parents that we serve are poor, undereducated, and among some of the most vulnerable members of our society. I urge you to give a favorable report on House Bill 223 because rights mean nothing if people don't know they exist. HB 223 is simple, and it does the same thing in CINA cases that Miranda rights have done in criminal cases for more than 50 years. It ensures that parents are informed of the rights that Maryland law already grants them. Basic rights, like the right to know the allegations that they're being investigated for, the right to speak with an attorney before signing a binding document, the right not to have a government agent enter and search their home without a consent or court order. But these rights only matter if parents know them, and it's a small, reasonable step to require DSS to notify parents at the start of an investigation. But I do want to be clear, HB 223 does not weaken child protection laws. If a child is in immediate danger, DSS and law enforcement already have the power to enter a home and remove a child. This bill does not change that. HB 223 does not stop DSS from acting when needed. DSS can still seek court authorization to remove a child and file a CINA petition. But most importantly, when parents understand their rights, they're more likely to trust the process, cooperate, and work with DSS, which ultimately benefits children and communities. Opponents argue that informing parents of their rights could put children at risk, but that's like saying Miranda rights make communities less safe. And as the U.S. Supreme Court has made clear, justice cannot be built on secrecy and coercion. Keeping parents in the dark when they stand to lose their children is not how Maryland should protect families.
Thank you.
For these reasons, I urge you to support this bill. Thank you.
Whoever would like to go next, please.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Natasha Calfany. I'm the managing attorney of the pre-petition program at the Office of the Public Defender. I'm asking for a favorable report on HB 223. Federal law and COMAR require DSS to inform parents of allegations against them. The Fourth Amendment provides protections against unreasonable searches and seizures of a person's home. The Fifth Amendment protects people against the deprivation of life, liberty, and property without due process. The Supreme Court has stated that the due process granted by the 14th Amendment provides heightened protection, not less, against government interference regarding certain fundamental rights and liberties. And it has also recognized parenting as one of those fundamental rights and government interference going beyond just the police. We also understand the ideas of consulting an attorney before entering agreements and entering agreements knowingly and voluntarily throughout the law. HB 223 does not give parents rights. It informs parents of rights provided to them by the Supreme Court, the Constitution, federal and state laws and regulations. I have represented children and parents in Senate proceedings. I currently represent parents in CPS investigations. And I just want to give you a couple of examples of how parents' rights are violated. Social workers have illegally asked hospitals to hold a child while they find a reason to take the child from the parent. We were contacted by the hospital to intervene. DSS has repeatedly forced parents to send their children to family or friends, then refuse to assist them in retrieving the child when the investigation is over and no abuse was found. DSS takes substance-exposed newborns from their parents who are successfully in treatment, though the law says they shouldn't. And DSS consistently threatens foster care when parents ask questions regarding process and safety. For these reasons, I'm asking for a favorable report on 223.
Good afternoon, Mr. Chair, Honorable Vice Chair, and members of the committee. My name is Kenneth Wardlaw. I'm a supervising attorney for the Office of the Public Defender's Parental Defense Division. I'm testifying today to urge you to issue a favorable report for HB 223. HB 223, as you've heard, would simply codify what is already expected from a worker from the Department of Social Services regarding providing information to the parents of their rights at the time of the investigation by DSS. These rights are already protected by the Constitution as well as other law and regulations. One thing we expect that will be a positive result of this bill is that it will make a more cordial working relationship between the department and the parent in these types of investigations. Currently, the threats by the investigators to remove the parents' children if they do not instantly comply with the investigation, providing immediate answers to their questions, allowing uninvited access to the family home, and unfettered access to the children only serves to complicate the department's investigation of the matter. These threats only enhance the concerns of the parent that the department, the government is trying to rip their family apart by removing their children, and it poses a governmental overreach to these parents. What the suggested language of this bill does is to make the job of the Department of Social Services worker easier. It does not, however, make the job of the worker or the police more difficult. It does not seek to change in any way the authority that either have to protect the child within the confines of their already existing authority. It simply mandates the parents to explain the rights. So I urge the committee to issue a favorable report for HB 223.
Thank you.
Thank you, Mr. Chairman and members of the committee. My name is Bae Golphin, and I'm here from Maryland Legal Aid to urge a favorable report and eventual passage of HB 223. Our firm represents some of the most vulnerable people in our state. Our clients are almost entirely low income. They are often survivors of domestic violence. Many do not speak English. They are also children who have been declared by the state to be children in need of assistance following findings of abuse or neglect. From that perspective, we believe that this bill strikes the right balance between the state's undoubtedly important role in protecting children and protecting the fundamental privacy and due process rights of all Marylanders. As my colleagues have said, the main purpose of this bill is to put parents on notice of rights that they already have. However, many, including our clients, are currently too scared to do anything but comply. One client told me, when you hear CPS, you hear someone is coming to take your children. It's like what people say when police hold them at gunpoint. I just did whatever they said because I didn't want my baby to end up in foster care. You've heard, and I will refer you to the numbers in my written testimony, that the vast majority of investigations initiated by the department are closed without a finding of maltreatment. But I'm here to tell you that that does not mean that these investigations are being closed without causing very real harm. I want to tell you about one particular client of mine. In the midst of a contentious custody case, the child's father accused my client's other children for the third time of molesting and raping the party's then 6-year-old. As she did each time she was contacted by CPS, my client, in fear, signed whatever safety plan was presented to her. In this case, a rape kit was performed on this little girl, the third invasive genital exam she would endure before finishing first grade. She was separated from her mother and older siblings in the home where she spent every night of her life for a month while the investigation went on. Her adolescent siblings were interrogated and accused of doing unspeakable things to their little sister. My client, who lives paycheck to paycheck, missed multiple days of work, getting everyone to interviews and then their ensuing therapy appointments. In the end, the abuse was not only found to be unsubstantiated, it was ruled out. And still, over a year after that investigation was closed, this little girl's siblings would not speak to or be alone in a room with her after what they had been accused of. Just some of the lasting effects of an investigation their mother had no idea she could protect them from, and I urge a favorable report.
Thank you all very much. We'll take questions from the committee, and then we'll start working through. There are quite a few people signed up virtually. Delegate Eric Hand to begin, please.
Thank you, Mr. Chair. Thank you all for being here. And that is one of the most disturbing stories I've ever heard of a CPS case gone awry, although I've heard of many, frankly. My office has had at least 3 people over the time I've served who have contacted me for what turned out to be completely false allegations, some of the most disturbing things I've ever heard, because I'm sure Delegate Crutchfield would agree, what higher penalty could a person experience than the penalty of losing your children? And why would we not essentially Mirandize parents when they're under this type of situation? I can't think of what harm that could cause. There was a little bit of opposition testimony, so I just wanted to give the delegate an opportunity to address it. I don't know if you've already taken a look at it, but if you have any comment on some of the opposition, there's frankly not much, but yeah, please.
So yes, most of the opposition was to what would be the original bill.
Okay.
It has been amended to take out the greatest concern that people had, which is there was an exclusionary rule in here.
Okay.
And we have now taken that out. We've also clarified a lot of the language, and a lot of it is based on discussions with DHS.
Okay.
And I'm frankly a little disappointed by their informational letter, because we've had lots of contact with them and had come down to a point where we had agreed on many pieces of this legislation, including those amendments. Because, you know, one of the things I think that they've raised is that this looks like more of a criminal investigation situation, which is really not true here, okay? And in fact, if you go to Family Law 5-706, it talks about the fact that the law enforcement, the various parties involved can actually sign an MOU to investigate together.
Okay.
So criminalizing is not what we're attempting to do. We're already showing and just providing a clear way for parents and guardians to know what their rights are. So I appreciate that very much. Thank
Absolutely.
you.
Thanks for your work
Delegate.
on this.
Any other questions for this panel? All right, seeing none, thank you very much. And that does not conclude anything. We're going to go now to the people who are here virtually, and I'm going to go through the list. and we'll go through those. I know there are several more people, I think, who are here in the room to testify. We'll get to you, but just quite a few virtual people, so I'm just trying to make sure I get everybody on the list. Melissa Wisniewski is there. Jessica Moranto is there. Kayla Gray. Is she's there?
I'm here.
Okay, good. Hang on one second. Aubrey Edwards-Luce, I see on the screen. And Christina Hawkins. I think there are other virtual people, but we'll go with those 5 right now, and then I'll figure out everybody else. So let's start with Ms. Hawkins, please, for 2 minutes.
Hi, my name is Christina Hawkins. I'm the statewide peer support manager for the Office of the Public Defender. However, today I'm testifying on my own behalf and asking for a favorable report. On February 23rd, 2018, a woman who identified herself as a CPS worker and a police officer knocked on my door. I answered the door and allowed these strangers in my home because I had no reason not to. I had been taught that police were here to protect and serve. I had never been in trouble with the law and had never had any contact with Child Protective Services in the past. The CPS workers said they were at my house because they had a report for suspicion of drug use. They did not ask me to take a drug test, nor had they taken one before. They looked around my house and found no risk of harm. My 3-year-old daughter was laying on a made bed in her own room in a home that I owned. The caseworker then walked outside and made a call. She came back in and said I had to sign a safety plan and to agree to give custody of my child to someone else or they were taking her to foster care. I began to panic. I didn't know that I was entitled to representation or that I had options and rights. I signed a 60-day safety plan that ended up with my being separated from my child for 3.5 years. Parents are entitled to know they have the right to get advice from an attorney before signing away custody so they understand the risks involved in life-changing legal matters. The department abuses their powers by not informing parents of their rights and targets individuals who wouldn't know any better. If House Bill 223 was in place on February 23rd, 2018, I would have been able to plan accordingly for my child in a way that didn't traumatize us. Today, I stand before you with 6 years clean, 3.5 years reunified, a milestone I was told that I would never achieve, and I can tell you with certainty that the day my daughter was tragically pulled from my arms was the most confusing, emotional, and traumatic day of both of our lives. Today, I work to ensure that others don't face the same trauma I once had to. I hope that you issue a favorable report for House Bill 223.
Ms. Wisniewski, please.
Good afternoon. I am a parent in favor of HB 223. I am a mother of 2, but because the CPS worker failed to inform me of my rights, only one of my children lives with me today. A false complaint was made to DSS alleging abuse of my daughter. I was called by a CPS agent and asked to set up a home visit regarding my minor daughter, but I was not specifically informed of the allegations. I was informed, however, that this was a non-emergency situation. A CPS worker came to my home, interviewed my daughter, my partner, and me. I believe the conversation was going well until she stepped outside to make a phone call. When she returned, I saw my daughter entering the room with her bags packed. I was shocked. The CPS worker had told her during the interview to pack her things because she'd be leaving that night. I was blindsided. I've always provided a safe, stable home environment for my children, and I couldn't understand why one of them was being taken away. Then I was given an ultimatum: call someone immediately to take my daughter or she'd be placed in foster care. I was handed a safety plan I did not want to sign. I was pressured, I was scared, and I was never given a copy. Although my daughter was never determined to be in imminent danger and the case was ultimately closed, it's now been 8 months and she's been home. The grief of losing her is unbearable. No mother should have to endure this pain. My family carries the scars of that day, a day that could have gone differently if only I had been informed of my rights. I wish I had known I had the right to speak with an attorney, the right to refuse to sign documents I didn't understand, and the right to challenge their decision before my child was taken. If I had known my rights, I could have fought for my daughter that night. I share my story so no other parent must experience this nightmare. Knowing your rights can change everything. Thank you.
Ms. Moranto, please.
Good afternoon. I, Jessica Moranto, respectfully request that the committee issue a favorable decision on House Bill 223. In 2008, my son Junior entered the world substance exposed, and consequently, a social worker knocked on my hospital room door. She appeared friendly, smiled, and spoke in a caring tone. While snuggling my newborn, I spoke openly. I had no idea that she was there taking notes, investigating me, and was picking apart my entire life. I had no clue that every word I said would be used against me over and over again in court and valued in court despite correct context. I was an addict, not a woman with a degree or even a high school education. Unknowingly, with full trust, I disclosed personal and detrimental information. As a result, both Junior and my daughter were taken out of my care that day. My home was unsafe because my child was born substance exposed. Me feeling stress equaled the need for mental health treatment. Me getting frustrated with my kids equaled the need for parenting classes. I raised my voice sometimes equaled the need for anger management. I walked to the store sometimes equaled unreliable transportation. This specific incident is an origin story of my broken family from a woman of privilege that's asking for your favor on House Bill 223. I was taught my entire life that I should listen to and trust people in authority, yet my children were taken despite a clean home, running water, a crib, diapers, electricity, a parent with a full-time job, and love to give. I was blindsided and never told I was under investigation. I never feared that my transparency could be flipped and abused in such a way. My complete lack of knowledge allowed people to come into my hospital room and my home and violate me. My family was traumatized by an upper hand that took full advantage of my ignorance. At any time, had I been informed that I was under investigation or that I had a right to ask for legal advice, things would have turned out differently. Every day with 10 years of sobriety as a parent advocate, I witness parents go through these same situations. It's my duty as a woman with lived experience to advocate for people like me. I'm not asking that we change the rights or manipulate the ones currently in place. I'm only asking for your support to inform members of our community of what their rights are before their families are investigated and dismantled. Thank you for hearing me today.
Thank you. Aubrey Edwards-Luce.
Good afternoon. I am the executive director at CFCC, but I'm here today testifying in my own personal capacity. I was a social worker who became a lawyer for kids in foster care, and I've been serving children at risk of abuse and neglect for over 15 years. And I'm urging a favorable report for HB 223 because providing a clear notification of parents' rights will help parents protect children from the trauma of unnecessary investigations and unnecessary separations that we've heard so many people testify about today. You know, investigations, even if they don't lead to removal, can cause extreme harm to children. Children are awakened in the middle of the night by strangers. They're asked deeply personal and intrusive questions. They're often talked to about sex. Sometimes they're hearing words for the first time about sexual activity that they've never heard before. And they're also asked to remove their clothes so that strangers can inspect their naked bodies for marks and bruises, even when there aren't even allegations of physical harm. And through all of this, many of these children understand the threat of being taken from their families is just looming. And that stress can cause at least the kind of stress that's comparable to that of a criminal investigation, but in children. Any caring parent would want to protect their child from this type of intrusion, especially if it was unnecessary, right? Investigations are the type of experiences that should require an informed consent or a judicial order. And HB 223 makes sure that parents know that they have the right to speak to an attorney so that they can provide just that, an informed consent if necessary. We should all be encouraging parents to be informed so that they can hold the government accountable and require CPS to meet the recommendations or the requirements to be able to get a judicial warrant, unless there's of course a risk of immediate serious harm. When I attended a local listening session with families who've had CPS involvement, they talk with clarity about the role that CPS has. They understand that despite the rosy depiction that's found in the Parents Guide, that CPS's job is to judge and separate them. And so we want to make sure that parents know that right from the beginning, and I'm urging a favorable report for HB 223.
Thank you. Thank you very much. Kayla Gray, I think. There we go.
Hi, good afternoon. My name is Kayla Gray. I am a person in long-term recovery, and I am a mother to one. Although I am not representing them today, I am employed by the Office of the Public Defender. I'm a parent advocate, and I work towards reunification with parents that have had their children removed. I'm asking for a favorable report for HB 223, and this is my testimony. If only. There is a knock at my door and I see the police. They're here to take my child along with my peace. In the hospital or in my home while this is happening, I should not feel alone. If only I knew that an attorney should speak. Perhaps in my arms, my child I would keep. If only I knew I did not have to let them in. Perhaps I could have stopped this before it began. But why are they here? What allegations? I do not know because my rights were not stated. What do I do and who should I call? Consumed with fear, I knew nothing at all. They came through my door and ripped my child from my breast. If only I knew that I was allowed to contest. I pleaded and I cried, saying anything I could. If only I knew that my words would be so misconstrued. Information is power and they conceal mine, leaving me helpless. That is the real crime. If only I knew that my silence could save me, I would have kept my mouth shut and kept my baby. How could I have known that my cries would be used against me? I could not have known because my rights were not read to me. Thank you.
All right, are there questions for this panel? Okay. All right, seeing none, we thank you all very much for testifying here today. I believe the remaining people are all in person. I have Tara Garcia. Let's see, yep, there we go. Shanta Trivedi. I don't know if Bailul Golfin was in the first panel or not. I don't think so. Oh, you were. Okay, I apologize. Didn't mean to do that again. Amber Dorch. Chelsea Gray. Dorch, Gray, Garcia, Trivedi, Cloud. Oh, Cloud. Aaron Cloud. All right, great. Normally I start on my right and move to the left. So if you'd like to begin, and the microphone, just press the button. We now tell people to press the button. It's very confusing. All right, and please go ahead in 2 minutes.
Thank you. My name is Erin Miles Cloud. I am a Baltimore native, a mother of beautiful children, a sister, a cousin, an aunt of many people who've experienced the child welfare system in Baltimore City. I'm also the senior civil rights attorney in the Families Department at Civil Rights Corps. I submit this testimony in support of HB 2023 on behalf of Civil Rights Corps, a nonprofit specializing in innovative systemic change, civil rights reform through litigation, advocacy, and public education. For over a year, Civil Rights Corps CRC has been investigating the Maryland child welfare system, also known as the family regulation system or policing system, a term that we're going to use to honor the ways that people who have experienced this system talk about this system. I submit this testimony with firsthand personal knowledge in my personal capacity, but in my professional capacity of the very onerous and intense surveillance that Maryland families are being subjected to when there is an investigation, not even just the court case, but an investigation. HB 223 will help protect the rights of these families. In particular, it will protect the rights of already marginalized families, in particular Black and brown families. The Know Before They Write Act will act as a safeguard to Black and non-white families who are disproportionately facing investigation. Similar to the criminal legal system, this system subjects Black families at a disproportionate rate. Nationally, 1 in 2 children, Black children will experience a family policing investigation. 1 in 10 will experience family separation. This trend persists in Maryland. Although Black children make up less than 1/3 of the state's population, 56% of those children in the system are Black. What this bill is asking for is a simple safeguard and procedural protection for the fundamental rights of families, in particular, the rights of Black and cash poor families who have been subjected and are facing this system at increased risk. It enforces a right that already exists for these families and simply creates an opportunity for protection, not punishment.
Is this good? Okay, great. Good afternoon, Chair Clippinger and the Judiciary Committee. My name is Chelsea Gray. I'm a clinical social worker and resident of Baltimore City in Maryland's Legislative District 43A, and I'm here today requesting a favorable review of House Bill 223. While I'm here today in my own capacity, in my professional role, I work on a multidisciplinary team with the Maryland Office of the Public Defender's Parental Defense Division, with parents at varying stages of trying to reunify with their children who've been removed by the Department of Social Services. As a social worker, I understand the challenges that arise in balancing safety and self-determination, and the challenges of working with clients who are involuntarily engaged in services. One thing that our profession holds true is that providing information upfront about the extent of and the ability to or repercussions of refusing to engage in involuntary services is key in developing relationships and improving outcomes for all involved. The parents and caregivers with whom I've worked throughout my career have always shown interest, care, and determination to do what's best for their children. One key thing to note is that this bill does not impact the timelines that exist for child welfare investigations, nor does it apply in situations that CPS screening has already determined to be imminently dangerous. There are no changes to these decision-making processes. This bill simply ensures that parents and caregivers who are being approached for the first time by DSS are informed of their rights as they already exist and provided the opportunity to ask questions and make decisions based on this information. I do not believe, as a social worker or as a human being, that the fear, shame, and confusion that typically characterizes these early interactions serve anyone's best interest, and these feelings are certainly not effective motivating tools for parents or caregivers who may need supportive services. As such, I'm requesting a favorable review of House Bill 223. Thank you.
Hello, is this good? Okay. Good afternoon, Chairman, Vice Chair, and members of the committee. My name is Amber Dortch. I'm a social worker for the Maryland Office of the Public Defender. I work with families who have been impacted by the child welfare system. Today, I come before you in my personal capacity as a resident of Maryland and as an advocate who cares. I am asking for a favorable report on House Bill 223. I strongly support House Bill 223 because it protects every parent's rights to be properly informed and treated with dignity and respect while under investigation or assessment by the Department of Social Services. In working with CPS on my behalf of my clients, they have expressed feeling dehumanized, shamed, and belittled by workers. I've personally experienced hostility over the phone. I've had doors slammed in my face. I've been ignored in person. I've had workers advocate against my assistance to my clients. House Bill 223 also promotes family unification in that it levels the playing field for parents and equips them with the knowledge, information, and resources they need in order to be able to fend for their children. Once I have fully informed my clients of their rights and responsibilities, I notice a positive change in their demeanor. They're confident, they're clear-minded, and less anxious when reapproaching their worker about matters regarding their case and child welfare. All of my clients will be better positioned for a favorable outcome when they are properly informed, felt believed, and safe enough to communicate with their worker without fear of retaliation by the department. I recently worked with a mother who wasn't aware of her rights, and as a result, her newborn was removed from her for weeks without any visits. When my team stepped in, we were able to help the mom gather appropriate documentation, such as just a simple safety plan, copies of releases. We advocated on her behalf in several meetings with the department and negotiated her son's return to care, including case closure. I believe that child safety is a priority for any parent, but I also believe in fair due process for the parent when being investigated. Supporting House Bill 223 has the ability to restore hope, give them a chance to defend themselves, preserve their family, and know before they knock.
Thank you.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Shanta Trivedi, and I teach and write about the child welfare system at the University of Baltimore School of Law, and I'm the faculty director of the Meyerhoff Center for Families, Children, and the Courts. I've also represented parents who have had their children removed without knowing their rights, and I urge you to issue a favorable report on HB 223. I want you to imagine the CPS knocks on your door in the middle of the night, and they say that they're going to search your home. They will search your medicine cabinet, your bedroom. They'll ask questions about your romantic partners, about how many glasses of wine you have each week. They'll ask to speak to your children without you being present and to inspect their naked bodies. How would you respond? Say, come on in? I doubt that. I know that I would tell them to come back with a warrant. I would call a lawyer immediately because I know my rights. You know your rights, but of course not everyone does. This bill simply puts marginalized families on equal footing with their more privileged counterparts. This bill would establish that constitutional protections apply in child welfare investigations and would allow parents to make informed decisions throughout the process. To date, Connecticut, Texas, Florida, Montana, and Arizona have all passed these laws, and New York and Delaware have introduced similar legislation. The question is whether we want to join those states in respecting parental rights for all parents or just for the privileged few. Rather than making children less safe, states that have passed similar laws have found that they keep children safer because transparency from the agency encourages families to be more forthcoming. Further, the law already provides for law enforcement and DSS to be able to enter in emergency situations, and this bill is not going to change that. I know that opponents do not want DSS to be perceived as a policing agency, but unfortunately, many parents already feel this way because of the intrusive nature of investigations and the threat that their children can be taken. Regardless of what the perception is, the fact remains that removing one's child directly impacts both the parent and child's right to family integrity and the parent's right to care, custody, and control of their children. This is true regardless of whether the police do it or if DSS does it. Because I believe this bill is an important step towards protecting family integrity, I urge you to support HB 223. Thank you.
Good afternoon. My name is Tyra Garcia, and I am a parent and a licensed social worker in the state of Maryland in support of House Bill 223. I am offering my testimony in my personal capacity to share the horrors of my lived experience as a parent unaware of her rights when involved with an agency such as DSS. Prior to my current position and obtaining my degree, I served in the United States Army for 16 years. I trusted government agencies and was proud to be a first-generation U.S. citizen and Army veteran. I firmly believe that when a parent is seeking help, human services organizations such as DSS should be mandated to present clients with resources and not criminalize their conditions, which begin by requiring DSS to inform us of our already existing rights. After my son was hospitalized for mental health issues, I felt helpless. Just moving here to Maryland with no family, I had no support. I turned to the Department of Human Services. My goal was to get the appropriate mental health services reestablished for my son that he had in a prior state. I engaged with DSS for 9 months before they charged me with neglect for not picking him up from the hospital. Before that, I thought that they were there to help. They assured me that we were on the same team advocating for my son to receive the services that he once received that maintained his safety and that would keep us safe. It wasn't until we went to court 9 months later that I realized that I was in a 9-month investigation of where me begging for services and resources was then criminalized and used against me. My vulnerability, my openness, and my desire for help were weaponized when an investigator told my son, "Your mother doesn't want you home," and me being labeled with neglect. HB 223 could have saved the integrity of my family. It would have given me access to understand the process and the situation we were truly in to better advocate for my son. My son, regardless of his actions at the time, had been a scared young boy, unable to understand his own mental health and limitations. Instead of supporting me as a parent to best support him, I was criminalized, and I still didn't know my rights. I thought my only option at the time was to allow the state to remove my son and refuse to pick him up, and therefore becoming neglect. I could not go back in time and undo the damage caused by my ignorance of not knowing my rights. But today I can stand before you in favor and support of House Bill 223, which simply states, requires DSS to inform parents of their already existing rights. I believe this bill is rooted in a shared commitment to protect our children while ensuring that families are treated with fairness, dignity, and respect. Thank you.
Thank you very much. Questions from the committee? Delegate Kaufman.
Yes, if they're concise, Mr. Chair, can I have 2 questions, please? Thank you. I just want to say, I think that is, this whole hearing has been one of the most disturbing hearings that I've been a part of in my 3 years here. So thank you for sharing bravery, sharing those terrible stories. Thank you very much. My question is, I forget your name. I have 2 questions. My first question is for the woman in the gray. Right, yes, you. Many of the people that told their horrible stories about not knowing their rights indicated that they thought the person was going to help them advocate for their children. They thought they were a partner in helping them with their issues. So I don't know how else to say this, but is it common in your experience for parents to feel deceived in the sense that they think that the CPS worker is a partner and then the bottom falls out?
I would say yes. In my experience in working with clients, it's pretty common to hear that, I thought that I was just, participating and doing what was best for my child. And then, I frequently hear parents I work with say, I didn't, they told me it would go one way, and then now here we are later, and they're, saying that what they told me before is no longer the case, and I have no through line to know why. And it is, it's punitive, and it's a challenge for them to navigate.
And for the woman, thank you, ma'am. And for the woman with the flowery shirt, I think that you mentioned about racial disparities in CPS and child home removals. And so I was just wondering, and I could have missed it, but do you have data or anecdotes that highlight the racial disparity in child protective services removals?
Yes, I think maybe you're referring to my testimony where I touched on the racial disparity.
Yes.
And if you see, I have submitted written testimony with footnotes to all of the data. The Kids Count Data Center from Annie Casey Foundation, alongside multiple studies across with Dorothy Lee Roberts, there's a SLAC study, a Berger study. But yes, there is an overall disproportionality in the foster system generally, and in particular in Maryland.
Mm-hmm. And that, just one last follow-up. Do you think that's because of a lack of cultural competency on the training on the part of CPS workers?
That is definitely a part of it. What I would say is one of the major drivers, which is also in my written testimony, is the economic neglect that many Black families are facing, and the interrelated ways that that economic neglect is then labeled as parental failures or family failures, which then puts people more likely to face an investigation. So if you understand, if you're living in a space, a shelter, a public housing that is filled with mandated reporters, you're gonna have increased likelihood of facing investigations, which unfortunately in our system and our state and in my city, Baltimore, Black families are facing more regularly.
Thank you, and I will read your testimony. I just didn't have an opportunity.
No problem, no problem at all. Just didn't want to bore you with sites.
All right, seeing no further questions, thank you all very much. That concludes those people testifying in favor of the legislation. Now we're going to hear from those people opposed to the legislation. Jennifer Stein, Judith Chagrin, and Michael Calabrese. Michael Calabrese?
Hi, speaking.
Oh, and you're virtual, okay.
Yeah, I'm virtual, sorry.
All right. Whoever would like to go first? All right, we'll do it. Okay, who?
Hi.
So there's another person testifying in favor at the table?
Yes, and I did sign up to testify in person.
All right, I'm going to take the opponents first, and then I'll come back to you after questions. Please, let's go with that.
Thank you. Hello, Mr. Chairman, Vice Chair, and members of the committee. My name is Jennifer Stein. I'm the Executive Director for Court-Appointed Special Advocates for Children of Baltimore County. I'm here representing the Coalition to Protect Maryland's Children, which is a group of child welfare experts, attorneys, medical professionals, and others who are speaking solely from the perspective of the child's safety and best interest. I agree wholeheartedly. I am also a mother, and I agree completely that these are horrific stories that should not have happened the way that they happened. But we are concerned that this bill does not fully address that problem. We are also in full support, complete support of parents knowing their rights, knowing how to execute them, and knowing what they can and cannot do in order to protect themselves and their children. Unfortunately, we are concerned that the way that this bill is written, it leaves room for risk of safety to children. The way it is written now, we're concerned that social workers will have to rely more on the courts and on police intervention, whereas right now when a social worker comes to the door, unless there are extenuating circumstances, typically they don't come with law enforcement initially. And this escalates that from the beginning. We also have concerns that if a child is not able to be seen, which the way that this bill is written, it is not clear. We have concerns that either there will be too few removals because people are not willing to push the issue, or that there will be too many removals because workers are concerned about what they are not able to find out, which really, on the whole, may just lead to the wrong children being removed, which, as we heard from the mothers, is traumatic for everybody. We have spoken with the delegate, Delegate Crutchfield and her office, as well as other people. We are very happy that some of our recommended amendments were accepted. We just feel that there is more work to be done. So we ask for an unfavorable finding for this bill. Thank you.
And I am Judith Shagrin. I had some notes all collected and put together, and now they've changed based on what I've heard. Let me say that I am a retired social worker and a child welfare expert with decades of experience, including in child protective services investigations. I've never woken a child up in the middle of the night. I've never asked a child to strip. That actually is not the way we operate. I am deeply concerned, and we do not go out with an intention of removing. In fact, despite the impression that's been presented, Maryland is among the lowest states in the removal of children at 1.1 per thousand, and less than 5% of interventions with child protective services lead to separation. When a child is separated from their family, everybody gets a lawyer. So the idea that parents' rights aren't being protected, in fact, is not accurate. Everyone has a lawyer. I'm deeply concerned that as written, 233 will put children at risk because it may block or delay contact that the worker needs to have with the child in order to assess for safety. The recourse that's offered is the removal of the child. That's the most extreme measure we could take when, if a parent works with us and we're allowed to interview the child, as some of these folks said, the allegations weren't even true. Without an interview, without being able to talk with the parents, we don't know. And 233 allows us instead to remove a child. And we don't want to take that kind of extreme. What if a child is being sexually abused and the offender answers the door? What incentive is there for him to cooperate with the child welfare worker and allow access? Or how about a parent struggling with severe depression and substance abuse, caring for a toddler crawling among needles, roaches, and spoiled food? Each parent gets a pamphlet from DSS. I believe they included it in their information, and that provides parents with the information they need. Anything that's going to delay seeing a child presents a risk to child. I totally support parents' rights, but I ask you today to stand up for children's rights.
Mr. Calabresi, please.
Thank you. Good afternoon, members of the Judiciary Committee. My name is Michael Calabrese. I'm a senior assistant state's attorney in the office of the state's attorney for Wycomico County. I'm assigned to the Child Advocacy Center, and I prosecute primarily crimes against children, child sexual abuse cases. And I'm here on behalf of the Maryland State's Attorneys Association to urge an unfavorable report on House Bill 223. I think some of what's getting lost in the writing of this bill and the language of the statute is that these statutes are designed to protect children, and that's getting lost because by the writing of this, it would necessarily diminish the rights of children in favor and shifting a focus point to parents and or caretakers. And I think, any roadblock to child safety in an impartial investigation, such as a CPS investigation, necessarily has invariably awful consequences. It can lead to spoliation of evidence, concerns for coercing victims and witnesses. And it's important to note that the body of the statute kind of envisions an adversarial nature that's not necessarily present in a DSS investigation. It puts them almost in an adversarial position where they're almost imputed as investigators or law enforcement, and that's not their duty or right. They're concerned with child safety. It even bakes in an implicit threat that if you refuse to allow an interview or entry into your home, we could take your kids. It puts them in an adversarial position. I also think some of the way it's written in the statute, it's self-contradictory in nature. It advises individuals of their rights, but then it provides that there's a backdoor and access point to that their rights actually don't matter if they want to exercise their rights not to let someone in their home or speak to their children, that it can get overridden by the statute itself. There are innumerable instances where this could lead to further detriment to children, and I'd be happy to take any questions on that point. Thank you.
Thank you, Mr. Chair. Thank you guys for being here. Does some of you work for DSS or no? You're just former social workers? Okay, I don't know if you saw the Baltimore Banner article recently that exposed the appalling increase in child deaths that have occurred. 2014 looks like there was about 20. 2020 there was about 50, and the latest record was 83 children dead from abuse and neglect. So it seems like the system's not working. And, I understand that you're retired, and I'm not sure when you retired, but something in this system over the last few years has utterly and completely failed. And it's not because we're telling parents what their rights are. So what could the possible cause be for such a disgusting increase in deaths?
One of the things that was mentioned in that report that was deeply concerning is that DHS hadn't kept track of its data.
Yeah, that was disturbing.
And so before I feel knowledgeable enough to comment, I would need to better understand what the deaths were, when they died, and what the cause was. Our social norms, for example, around safe sleeping have changed dramatically over the last 15 years. When children had what we used to call SIDS,
right?
We acknowledged the loss. Now we're forced to investigate to know whether or not there was abuse or neglect. So the changing norms may be a cause, but it's hard to know without actually having the data and reviewing each case.
Okay.
So, but it certainly is concerning, but that's why the idea we pass legislation that could delay seeing a child was so alarming.
Yeah, I guess my concern and my point would be we are already seeing an alarming increase, and it certainly wasn't caused by telling parents what their rights were. And it looks like to me DSS has no public plans to do anything other than try to get the maths better, which is embarrassing, frankly.
I also want to be clear, caseworkers are actually not professionally trained social workers.
That's good to know. We
call them all social workers, but some of them are, and the supervisors are. But a lot of what I'm hearing described today is workforce issues. How do we treat parents? How are we educated and trained? We want to be partners. And yes, I think Mr. Calabrese mentioned it sets up a policing relationship. We want to engage in a positive way.
Right.
That's how change happens.
Okay, I appreciate you guys coming in. Thank you.
Yes, this is for the CASA person. Good afternoon. Thank you for coming in. I really appreciate your expertise. In the proponents panel, we had numerous people, they were more polite than this, but who essentially felt duped by their caseworker or social worker. And my mother's a social worker, so I love social workers. But, you're talking about all the harm that Delegate Crutchfield's bill is going to do. But isn't the issue, shouldn't your focus be on retraining the caseworkers or social workers so that people can have the positive experience that the retired woman wants them to have, rather than feeling duped and that somebody was deceitful and things like that? Shouldn't that be the focus rather than just opposing Delegate Crutchfield's bill?
Thank you so much for the opportunity to respond. I absolutely do not oppose, I believe I mentioned earlier, I personally and the coalition does not oppose informing parents of their rights. I think that it is very important. Everyone should know their rights, and I also agree with the power differential that appears or that occurs when a social worker or other CPS worker appears at the door, and I understand that, and I think parents knowing their rights is very important. My sole concern is that this bill, the way it is written, and again, I'm not saying that there shouldn't be a bill like this. I just think that this bill in particular, the way that it's written, opens a door for many, many unintended consequences. I do also fully support retraining social workers. Actually, I would even love for all workers, all CPS workers, to be social workers, because social workers have specific training to engage families and work more closely with them rather than making it an adversarial relationship right off the bat. So yes, I agree with you fully that there should be this reform in the workforce. I think that's a great plan. It's just that I don't think this bill addresses what it's intended to address. If it solely said inform parents of their rights, I think we would be in support at this point.
Briefly, Mr. Chair. Isn't it so, though, that this is the first step in the process, the committee hearing, and there will be ample opportunity to edit the bill and make changes and different things like that?
So that is possible. We, as I mentioned before, we had submitted some amendments, and some were accepted, some were not. We were under the impression that there were others that were coming. We haven't seen them yet. So we're not opposed to continue working on this. We just are not in support as it is written now.
All right. Further questions from the committee? Seeing none, thank you, the two of you, very much. Now we'll hear from you for 2 minutes again in favor. Go ahead.
Thank you, Mr. Chairman and members of the committee. My name is Haley Lichterman. I'm the Deputy Chief for the Parental Defense Division at the Office of the Public Defender. And I did submit written testimony on behalf of the Office of the Public Defender that details a lot of the responses that I would have today before the committee. The things that I'd like to take the time right now to emphasize is that there's a lot of discussion here about removing children, and removal is almost this legal term of art in that the way removal is being used in this context is we're talking about a court-ordered removal by the circuit court. However, the vast majority, and if the members of the committee look at my written testimony where my numbers are going to be much more accurate than what I would say off the top of my head, the vast majority of children that are investigated are not removed. And in fact, tens of thousands of families are investigated, and it's the investigation itself that is also harmful and that we're not talking about enough. I really would urge that the committee think about this in terms of we're not pitting parents against children, even though that's sort of what a lot of the discussion in this hearing has been about. The whole idea of parents knowing their rights also prevents these informal removals where parents are essentially coerced into voluntarily agreeing to either temporary or permanent removals of their children that are actually never subject to any court oversight at all, which is also something that I discuss in my written testimony. The bottom line is if there's an emergency and the DHS worker or the police need to get in to see the children, the only option is not removal. Under Family Law Article 5709, which this bill does not modify, the police are still able in exigent circumstances to enter a home to assess the safety of a child. If there's a baby crawling around on the floor in a dangerous circumstance, if there's an issue of sex abuse, law enforcement can still exercise the ability that they have under the current law, and this law doesn't change that. So I'm also available to answer any other questions that were brought up by the opposition.
Questions? Seeing none, thank you very much. And that concludes the testimony on House Bill 223. We're going to go now to House Bill 542, for which there are two witnesses in person, including Delegate Crutchfield and Mario Walruzin. And then Erica Baylor from the Montgomery County government is not on virtually, but she's supposed to be. Yes, she is. All right, so we'll hear from Delegate Crutchfield, and we will go from there, okay? 3 minutes for Delegate Crutchfield.
All right, I'm back, colleagues. For the record, I'm Delegate Charlotte Crutchfield, representing Montgomery County, District 19, here to testify in favor of HB 542. So, this legislation will allow the local departments of social services to request the assistance of federal law enforcement officers when working on investigations of abuse, neglect, and exploitation of a vulnerable adult. Currently, when conducting these adult protective services investigations, there are only two categories of entities that the local department may work with and share information. And those are the local state's attorneys or appropriate law enforcement agencies, or the local office on aging or the Department of Aging, and or other agencies that provide services or care to the alleged vulnerable adult. Both groups may assist in the investigation at the request of the local department. However, there is no legal authority for them to work with federal law enforcement. And for example, when a local department is investigating a case of mail fraud, they cannot get authority to request assistance from the U.S. Postal Inspector. So it is this gap that HB 542 seeks to close. I would request a favorable report on HB 542. Thank you. I'm going to turn it over to my panelists.
All right. All right, thank you. Good afternoon, Chair Delegate Clippinger and Vice Chair Bartlett and committee members. Thank you for this time. My name is Mario Werzussen. I'm the Administrator for Adult Protective Services, which serves adults 18 through 100 plus when there's instances or allegations of neglect, abuse, self-neglect, or financial exploitation. And I'd like to express my support for this bill, House Bill 542, Adult Protective Services, Investigations and Disclosures of Information. Adult Protective Services in Montgomery County does hundreds of investigations as well. In Maryland, there are 7,000 plus investigations, many of which involve financial exploitation. This bill would strengthen the ability of Adult Protective Services to investigate and seek resolution of those cases with both local, state, and federal partners. And although Montgomery County has a robust multidisciplinary task force, which is comprised of law enforcement and the state attorney's office that reviews these adult protective services cases regularly, APS lacks that ability to directly collaborate and partner with federal law enforcement. This is of utmost import as the Consumer Financial Protection Bureau, the U.S. Department of Treasury, the Financial Crimes Enforcement Network describes financial exploitation as the most common form of elder abuse in the United States. With financial exploitation widespread with older adults, such crimes cause immense harm to victims and can be deadly. And there's lots of money, billions of dollars annually, that is reported that is stolen or scammed from our older citizens. Adding to the tools of Adult Protective Services by having federal law enforcement as a collaborative partner will strengthen the ability of APS to share information, work in collaboration, and ultimately enhance investigations that often run into barriers when financial crimes cross state lines and national boundaries. For these reasons, I request that you give a favorable report on House Bill 542. Thank you.
Ms. Baylor, please, for 2 minutes.
Good afternoon. Thank you, Chair Clippinger and Vice President Bartlett, for allowing me to testify today. My name is Erica Baylor, and I'm here on behalf of Montgomery County, Maryland, where I serve as an acting Adult Protective Services Supervisor. I work closely with Adult Protective Services investigator Amy Thomas, who has a specialty in financial exploitation. I am here to testify in support of House Bill 542. It would benefit Adult Protective Services to be able to share information with federal entities in general and the U.S. Postal Inspection Service in specific, because an important aspect of financial exploitation of seniors and vulnerable adults is that it can happen by mail.
We have had clients receive stolen property such as cell phones and laptops. They are then directed by scammers to send it on to people who are often other victims in an elaborate shell game where the property is moved quickly so that the perpetrators avoid being caught for the original theft. We have also had clients send checks and cash money through the mail. Another example of how the mail is used to perpetrate crime, a client responded to several fraudulent letters which made it seem as though funds that she had provided to a scammer were facilitating the release of $4.5 million from a bank in Africa. Her husband was unable to stop her from giving away money, and she gave away an estimated $130,000. As with the vast majority of these cases, none of that money was recovered. The FBI has reported that scams targeting individuals aged 60 and older caused $3.4 billion in losses. The state's attorney's office in Montgomery County does not have the resources to prosecute these criminals.
Okay.
Thank you.
Thank you. Are there any questions for this panel? All right, seeing none, thank you very much. Well, then ask the question. Wait a minute, we may have a question. Go and ask the question. Go and ask the question. We're not done yet.
Thank you, Mr. Chair. Sorry, I was asking the heir this question, and you're here, so why don't I ask you?
Yeah.
Why can't you all do this now? Why couldn't the federal, why doesn't this already exist?
Well, it's not in the law currently. That's why we're here.
No, I guess what I'm saying is, are there even like informal agreements or anything? Or are we all on our own? Have we been on our own with this?
Our county attorney advised that we can make a report to federal law enforcement. However, we can't have a full discussion or collaboration, and it's because it's not in Maryland law. So that's what we're asking, that there would be this change so that we could do that. And in particular, we're talking about financial crimes when scammers, for instance, ask that money or gift cards be sent in the mail, or they're moving property through the mail. A postal inspector really could help us out when it's crossing state lines, going even international. We really can't have that full collaboration as we do with law enforcement and state attorney currently because of the law. So that's why we presented it. And
Right, it makes sense.
yes,
Thank you.
Sure thing.
All right, now, are there any further questions for this panel? Seeing none, we thank you very much. Could I ask Delegate Crutchfield if you would humor me, and would you yield the table, please, for a moment, because we need to do some very important work of the government. Could I please summon Matthew D'Ambrosi to the table? Matthew D'Ambrosi? Mr. D'Ambrosi, would you please go to the table? Madam Vice Chair, would you please go to the table? Yeah. Ladies and gentlemen of the committee,
You put on your glasses.
Mr. D'Ambrosi is committing perhaps mortal sin, but he is leaving the employment of the vice chair of the committee. And since we have a minute or two here, and I apologize for people who are waiting, but we need to take care of this. There are questions from the committee for Mr. D'Ambrosi. Delegate Valentine.
Thank you, Mr. Chair. I have quite a few questions, actually. My first question, and you do not have the right to remain silent, so let's just say that, get that out of the way. You have no Miranda here. Is it true that you and the vice chair's daughter share a birthday?
Delegate Valentine, that is true.
Okay.
No, I have more, Mr. Chair.
Do you have more?
I do have more.
Oh, really? This is interesting.
Okay. Could you give me an idea and be specific about how long, or specifically how long you've worked for the vice chair?
Oh, Lord.
I began my employment with the vice chair on December 1st, 2021, and I left January 6th, 2023, and then I returned back to work for Delegate Bartlett as the vice chair December 1st of 2023, or excuse me, of 2023, and have resumed that employment until February 17th, 2025.
Very specific dates. I like that. Now, this leads me to my next question. So you're obviously leaving employment. Where would you might be going to work?
I'm joining the Anne Arundel County Fire Department.
So I'm presuming that you were provided a good reference by the vice chair?
I think that presumption's accurate.
Okay. And my last question is a statement followed up with a very poignant question.
Isn't that so?
Isn't it true that you will be out protecting the citizens of Anne Arundel County and doing that with very, very noble means in a noble profession? I wish you all the best for working for the second best fire department in the state of Maryland. Isn't that so?
Thank you, sir.
And my last statement, Mr. Chair, if I can, I only say that because it is truly a wonderful profession. It's a noble profession, and that my son actually works for the Baltimore County Fire Department, and his wife do as well, so I had to make sure that that was included in my questioning. Good luck, and be safe.
I appreciate it. Thank you.
But we're not done yet. No, we're not done yet. Delegate Williams.
Thank you, Mr. Chair, because I do have a question as well. So, is it true you would rather put out fires in Anne Arundel County than the fires here in this committee?
The fires here in this committee, I think, are maybe a little too much for me to put out. Delegate Williams.
Great question. Great answer. Well, we are going to miss you. I know the vice chair is going to miss you. We all are going to miss you. And good luck in your endeavors. And yeah, we're really proud of you.
Thank you so much. Thank you so much.
Delegate Embry.
So my question is, it seems like law school, reserve, active deployment, working for the vice chair are just too easy. And you need to now run into burning buildings as a way to challenge yourself. Is that correct?
I think that's a fair assessment. You know, at the heart of it, my dad was a Prince George's County police officer. My mom worked for, yes, of course. My mom worked for the Maryland National Capital Park and Planning Commission, so in Prince George's County. So I grew up, you know, these were dinner table talks, a lot of the issues you guys talk about here in the committee. So I'm a public servant at heart, and you know, I have a desire to kind of get out in the world and get my hands dirty in a good way, and now felt like the time to do it.
Well, we're so proud of you.
Thank you so much.
Delegate Grammer.
Thank you, Mr. Chair, and I'll remind you that you're answering these questions under the penalty of perjury. Please keep that in mind.
But nobody. Not really.
Oh, sorry. Is it true or is it not true that you failed to tell your boss and colleagues how much fun Pub 1767 was until your last week of employment?
Outrageous.
Delegate, that is true, but I will.
Keep going.
But I will say that, you know, I've teed it up for him going forward. And I think I even showed him the back entrance to the pub, and I can show you as well if you would like, sir. I think it's a place that might be up your alley as well.
I reserve the balance of my time.
I have one last question. Isn't it also true that you've protected your boss in a lockdown? That you stood faithfully by her side whenever she asked, sometimes didn't ask, but looked like she needed your help? You're able to finish her sentences because you have taken the time not only to understand every aspect of your job, but hers also? And is your true identity actually unknown, but you are in fact a superhero disguised as a chief of staff, and that you'll be sorely missed?
Yes.
Mr. Chair, thank you. I would like to say, I think I agree with a lot of what you said. But
time for everything.
The most valuable thing I think you can give somebody is the chance to be themselves. And Delegate Bartlett, Sandy has given me that time and time again. She gave me a chance, literally off the street. I was working security in Baltimore City before this, and she took a chance on me. And each time I think I'm going to tell her something that's, I can't possibly tell her something more crazy than the last thing I told her about, my dreams and my goals. She's allowed me to do it every step of the way, and I have loved every second of it and would do anything for her at any time. So thank you.
Mr. D'Ambrosi, it's possible that your current boss, I don't think that she could, she loves you quite a bit. And it's clear to see that you love her quite a bit. And the work that you've done for her and for this committee has been outstanding. And so we just wanted to take a couple minutes here in the middle of the briefing, in the middle of the hearings, for the world to know that and to appreciate you and the other staff people who work for us every day here in the committee and here in the General Assembly. Thank you very, very much for your work. And you are required to be here on Sine Die. Thank you very much. Thank you very, very much.
Thank you.
All right, we're going back to work now. And Delegate Stewart is here. Delegate Stewart, we're jumping him in front of Delegate Crutchfield for House Bill 497. And we're going to go ahead and we'll take his people in person. There are a couple people we're taking virtually, and we're going to probably have to give one of them a couple minutes, I think, to get in the room. But in person, I have Sarah Stusek and Emily Block, right? Okay, I don't think there are others. Delegate. Lori Townsend, are you here? If you're here, you can come on up. If you're not, that's fine. All right. Delegate Stewart, please go ahead for 3 minutes.
Thank you, Mr. Chair. Great to see everyone, members of the committee. This is House Bill 497. For the record, I'm Delegate Vaughn Stewart. So try to remember back to when you were 13 years old and try to picture your childhood bedroom. You're lying there in the middle of the night. Let's say it's 1 a.m. in the morning. And all of a sudden, two huge men are standing over your bed. And you're confused, you're dazed, you might even be thinking you're dreaming, but they say, get up, put your clothes on, you're coming with us. Then when you try to ask what's going on, they put a bag over your head, a blindfold. When you try to scoot away because you see the door and maybe you think you can get out of there, they put handcuffs on you so tight that you think that they're gonna cut the skin and you're gonna start bleeding. When you finally do manage to make a sound and you say, what's going on, what's happening, they hit you in the back of the head. And they tell you that, again, you're coming with them. Eventually, you make your way outside where there's a black van waiting for you that they push you into, again, with no explanation. What I just described is something that dozens, hundreds, if not thousands of Marylanders have experienced, and it's all perfectly legal. Because in all of those situations, their parents contracted with what's called a youth transport company to take those teenagers to what's called sometimes a residential treatment program or residential behavioral program. Sometimes they're called wilderness camps or boot camps, but they're most commonly referred to as programs part of what's called the troubled teen industry. And this industry is comprised of for-profit companies that for large sums of money offer parents the ability to send their children somewhere where supposedly their drug treatment problems or alcohol problems or just general behavioral attitudinal problems will be magically fixed. This industry has come under a lot of scrutiny and regulation only recently. It was basically completely unregulated for a long period of time. Only recently it's been more scrutinized because people realized it was essentially bullshit the whole time. It was a scam. Lots of parents still to this day are paying for companies to subject their children to solitary confinement, to torture, to sexual abuse. No real education goes on. Very few teenagers actually get better or in any way put on the right path. And if These residential programs are the entree, the youth transport companies are the appetizer. Because when they go in and execute this legalized kidnapping to take the kids from their beds in the middle of the night and send them on to one of these treatment facilities, which are not usually in Maryland, they're usually in the Mountain West or in Utah, that's the appetizer because it sets the stage for the months or the years of abuse that's to come. This bill limits those companies' ability to pick kids up in the middle of the night, to bind them, to blindfold them, and I urge a favorable report.
Give me your name again, please.
I'm Emily Block.
Emily, if you'd like a moment, and I can go to the other person to testify, I'm happy to do that. I just want you to know that we're very happy to have you here, and we're very happy to hear from you today. But if you need a moment in any time during your testimony to stop and take a break, that's absolutely fine, okay?
It's okay.
Would you like to testify now, or do you need a minute?
I can go. I would rather get over.
Okay, that's fine. Go ahead.
Hi, committee. My name is Emily Block. I was removed from my bed at 16 years old in the middle of the night and brought to BWI Airport, shipped to Arizona, where I had, countless months of continual abuse. But we're here about the process of the kidnapping versus the program itself. The kidnapping was at 3 in the morning. They came into my room. I was 16 at the time. They put those zip ties around my wrists and brought me out of my home. No idea what was going on. Didn't find out until later where I was going. Got to BWI, sat next to the people that were taking me and didn't see my parents again for 18 months. How can you allow that to happen to your child? I don't know. I'm a parent of 5, I don't know. But, that night permanently changed my brain wiring and permanently changed it permanently changed me in ways that I don't think will ever be fixed. And I'm here trying to speak for, those like me that are still happening. It's still happening to, kids in Maryland, kids here. And that's all I have. But just please try to stop this from happening.
Thank you very, very much. Thank you. Please.
Thank you so much to Chair Clippinger, Vice Chair Bartlett, and members of the Judiciary Committee for allowing me to share my story with you. My name is Sarah Stusek. I grew up here in Annapolis, Maryland, 3 miles from where we sit today. 17 years ago, my life changed forever in a single night. I suddenly woke up in my childhood bedroom, a place I once considered my safe haven, and checked my phone. It was 4 a.m. I rolled over and tried to go back to sleep. Within moments, the lights in my bedroom came on. I reached for my phone, and it was gone. 2 strangers were standing over my bed. They restrained me while rummaging through my drawers and gave me an ultimatum: cooperate at an airport or endure a cross-country drive. And just like that, I was gone. The journey ended in Bozeman, Montana, where I was blindfolded in the back of a car with a gate, so that when I tried to escape, I wouldn't know how to find my way back to civilization. I was a child being treated like a criminal. Well, I consider myself very fortunate compared to many, despite living outdoors in Montana's winter backcountry. The trauma of that night has left permanent scars. I often wake up at 4 a.m., staring at my ceiling, unable to sleep. Even now, the logical part of my brain knows I'm safe, but the terrified teenager inside of me remains hypervigilant, waiting for strangers to appear in the dark. This experience was so profoundly life-altering that I've spent years processing it through my work as a filmmaker and writer. From telling my story, I've connected with countless other survivors who have endured similar trauma, each of us carrying the weight of those dark hours when we were taken from our beds. How can we expect to help at-risk youth by traumatizing them further? The very industry claiming to help troubled teens begins with tactics that inspire terror and break our trust. Today, you have the power to end these practices in Maryland. I urge you to pass HB 0497 to ensure no child in our state ever wakes up to strangers in their bedroom or faces the terror of being blindfolded, restrained against their will, and transported across state lines. Thank you all so much for your time.
All right, we're going to take questions for this panel, and then we'll go on to a virtual panel next. Delegate Arcan.
Thank you, Mr. Chair. Thank you guys for being here. Thank you for the bill. Thank you for sharing your story. I haven't heard a lot about this, but I did have a close friend in high school who had this happen to him, and he's no longer here today. So thanks for sharing.
Thank you, Mr. Chair. For the bill sponsor, explain to me why this doesn't get prosecuted as kidnapping.
Well, because oftentimes the parents will sign powers of attorneys agreements over or other types of legal documents with the companies, they actually essentially, for a temporary period of time, make these companies the legal guardian of the children, in which case it makes it very difficult to prosecute. And also, unless there's a serious injury, it's also very difficult to sue civilly over this, both because of the power of attorney agreement and also because the issue of damages is going to be hard to calculate.
And when you say power of attorney, you mean to the transportation?
Correct. The youth transport company becomes the power of attorney based on documents that the parent signs at the beginning of their financial engagement.
Okay, thank you.
Delegate Sample Hughes, then Kaufman.
Thank you, Mr. Chair. Thank you, Delegate, for this legislation. I too haven't heard much about this, so I do thank you for educating us on the subject matter. Can either one of you just explain to me, and first let me ask this question, are there many transportation companies in Maryland? Are they, okay.
Yeah, these companies generally operate nationally. So I don't know how many are headquartered in Maryland specifically, but if you Google around for youth transport companies, you can see that there are dozens of these that exist, and they generally will operate on a nationwide basis because what they need to do to be profitable is to pick up children in any state and take them to where most of these programs are located, which is the West.
So your bill would make changes to just the ones that are operating in Maryland?
Correct. So they would not be able to use these tactics like blindfolds and restraints on Maryland children. We can't obviously prevent them from going into Minnesota and taking kids to Utah. We can just do what we can do. And what we can prohibit them from doing is to use these tactics in Maryland for purposes of using our roads or our airports and then transporting them out of state.
I guess what I meant to say is the ones that are licensed in Maryland.
There's no licensure for these.
Okay, no licensure through this process at all. Okay. And then just to the witnesses, either one of you just share, prior to this happening, were you in therapy sessions or anything like that that your parents were engaged in at all? I just wanted to understand what led to that being the next step.
I was in therapy, but my parents weren't there with me, no.
So there was no therapy that you had prior to?
I was in therapy sessions, yes.
You were, okay,
Yes.
okay. And none for you?
I was not, no.
Okay. Thank you. Thank you for responding.
Delegate Kaufman.
Yes, I will be short, but I just want to make sure that Delegate Stewart has had a chance to read the Disability Rights Maryland favorable with the 10 amendments testimony, and if you have any thoughts on their suggested amendment.
I did. They're honestly, they're worried that the bill is not strong enough by basically allowing some exceptions to, in the case of restraining youth who present an immediate or possible threat. I mean, honestly, it's the committee's purview at this point. If you guys want to take their amendment, that's fine with me.
All right, thank you. Delegate Tolles.
Hi, thank you both so much for being here and sharing this compelling testimony. And I am so sorry to ask this question because I just don't understand. I've never heard this before. And again, I'm sorry that this is happening, but why is this happening? Why are parents why is this happening?
It's difficult to explain, Delegate Tolles, exactly how to get into the mind of the parent. I think that it probably differs by family and by parent. And I think probably if you asked 12 survivors, you'd probably have 12 different stories that their parents told them of why they did this. I think to try to be charitable, I think a lot of parents think this is the right step. I think that they have heard somewhere or read somewhere that these residential programs are the way to go to get their kids on a path that they think is better for them. And I don't think that obviously parents would put their children through a legalized kidnapping arrangement if they thought it was not in their best interest. It's just that they're misguided. They're either not doing enough research or they just heard the incorrect things. And as a result, they think that their kid has to get one of these programs to get better, and they're willing to use one of these youth transport services to get them to where they think they're going to get better. The reality is that the programs themselves are horrific, they're barbaric, and the way to, even if they were awesome, the way to get kids there isn't the best way to get kids there shouldn't mirror that same barbarism. And so because children rationally don't want to go to one of these facilities, they're not going to consent to that themselves. Parents are thinking the only way to get them there is to use a transport service that will kidnap them against their will.
Okay, Mr. Chair, just a quick, thank you, Mr. Chair. Can we just ban these programs in the state of Maryland?
Well, I think that this bill would get us a long way from doing that because these companies almost always operate in the middle of the night. They almost always use blindfolds and handcuffs and all these different things that the bill prohibits. And so if we pass this bill, we'd go a long way towards banning basically the entire business model of the companies. But we don't go so far as to say that if they want to transport youth during the day and not use any of these horrific tactics, the bill does not ban them. But certainly if the committee wanted to do that, I probably wouldn't be the one standing in your way.
Okay, thank you. I'm mortified that this is even happening, so thank you.
Likewise, thank you, Delegate.
You're welcome. Thank you, Mr. Chair.
Delegate Tomlinson.
Thank you, Mr. Chair. So the folks, sorry, I have an issue here in my throat. The folks that are doing this, they're actually taking you out of your house and transporting you. Are they licensed in any way? Like, are they special police officers? Are they essentially like?
No.
Nothing.
There's no licensure. Now, one thing I haven't mentioned yet that the bill does mandate is that they be trained to use these, to use any of this type of stuff, to receive adequate training. But right now, there's no regulations whatsoever. They're not having to be licensed in Maryland. There are no rules for how they operate. There's no standards for what they can and can't do. It's just absolutely the wild, wild west.
So it's just like two tough guys they could pick up at the bar and employ.
Correct.
Gotcha. Okay. Thanks.
Thank you so much. And I understand there is, federal legislation has been introduced, and mirror the federal?
That's a great question. You guys may want to offer more. There is federal legislation that President Biden signed shortly before he left office, but most of the legislation on both the federal and the state level is focused on the programs themselves, regulating the programs. Because Maryland either has few or no programs like this, the best way we can honestly take a crack at this barbaric industry is to regulate the transport process. There's no other pending legislation that I'm aware of that does that, but one other state has taken this step, Oregon, and that's what we modeled our bill after.
Terrific. Thank you.
All right, I think we're going to move to the people testifying virtually right now. Thank you both very, very much for being here this afternoon. And we'll now begin with the virtual testifiers. Paris Hilton, Kimberly Dougherty, Lauren Tenney, and Caroline Cole. Laurie Townsend, okay, come up to the table and we'll hear you after them. But we'll start with Paris Hilton, please, for 2 minutes.
Thank you, Chair Clippinger, Vice Chair Bartlett, and members of the committee. My name is Paris Hilton, and I am a troubled teen industry survivor and advocate. I'm here today because HB 497 is personal to me. When I was 16, I was ripped from my bed in the middle of the night by two large men I had never seen before. They gave me a choice, to go the easy way or the hard way. But there was no choice. They handcuffed me and carried me out of my room as I screamed for help. I was shoved into the backseat of a car and taken to an airport. I asked to speak to my parents. I asked what was happening and where I was going. They told me to shut up and grew more agitated with each question. I thought I was being kidnapped, and in any other context, that's exactly what we would call this. My parents had been sold a lie that this transport was the only way to safely get me to the facility. This isn't just my story. Every year, thousands of kids across the country are violently taken from their homes, handcuffed, blindfolded, and physically restrained, all under the label of youth transport. Does this sound like a legitimate therapeutic intervention to you? I can tell you from experience, this causes lasting trauma. I suffer from insomnia, nightmares, and PTSD because of my experience. I wake up crying and terrified that I'm being kidnapped from my home and locked into a facility where I can't escape. I don't wish this experience on anyone. Right now in Maryland, these companies operate with little to no oversight. HB 497 is a critical step forward, allowing Maryland to lead the way and make sure no more children are subjected to this inhumane practice in the name of treatment. These kids are our future and they deserve safety. They deserve dignity. They deserve better. Please vote yes on HB 497. Thank you.
Thank you. Caroline Cole, please, for 2 minutes.
Hi, thank you so much, Chair, Vice Chair, and members of the Judiciary Committee for letting us speak on this very important issue today. My name is Caroline Cole, and I'm here today on behalf of 1111 Media Impact, and we are in strong support of HB 497. Similar to many of the stories that you've heard here today, I also was forcibly taken from my home and transported to a facility when I was only 14 years old. Interestingly enough, I just talked to my mom about this a couple of days ago, and she still feels that this was one of the biggest mistakes that she's made in her life. But despite this, I would really like to speak to the broader issue. So really across the country, we have seen this lifelong impact that this has on youth who are transported to these facilities in this way. As you've heard, a lot of times it feels like an abduction, it feels like a kidnapping. And so to kind of give a broad overview, so as you've heard now, they are waking these kids up in the middle of the night. They're using restraints, blindfolds, they're putting bags over their heads, handcuffs, you know, you name it. And this is very deeply traumatizing, and it's leaving children fearful, disoriented, and feeling abandoned by the very people that they're supposed to trust. So, you know, let's be very clear about this. I'm a mom. I have 2 kids. I have an 11-year-old and a 3-year-old. And if I did this to my children, if I handcuffed them, if I put bags over their head and forced them into my vehicle, you know, this is child abuse, clearly. And so it should be the same thing when we're hiring someone to do that same practice. So I encourage the committee today to issue a report of support for HB 497. And thank you so much for your consideration and time today. It means a lot to our entire community of survivors.
Thank you very much. Kimberly Doherty.
Good afternoon. Thank you, House Judiciary Committee and all the legislators here today. And the true thanks goes to the survivors who are here and brave enough to speak about the horrors that they have gone through. It is incredibly tragic and sad. And they are here not only on behalf of themselves, but on behalf of the many of them that are no longer here today. So many survivors have either died by suicide or died of accidental overdoses in an attempt to treat the pain that they've suffered as a result of being in these facilities and taken from their homes in a way that is just like kidnapping. Thank you, survivors, for bravely moving forward on this legislation. And to Delegate Stewart, we commend you. We commend your bravery. We see you, we hear you, and Maryland hopefully will make the right choice to get this law in place. I can tell you as a lawyer who represents survivors in this troubled teen industry, I've heard so many horrific stories like this, and this needs to end. And it starts here. It starts with these companies. This has been an issue that has been ongoing. This is not new. And it is sad that the legislators today are first hearing of it. I can tell you in my written testimony, I cited to an article back in 2014 where these transport agencies were constituting what's called child abuse. These authors, these experts were opining in 2014 that these youth transport companies did things like kidnapping. They used the words false imprisonment. They use the words facilitate unreasonable and unlawful conduct. 11 years ago, experts were speaking out and screaming for regulation and change. And now with Delegate Stewart's regulations that he's proposed to Maryland, we're finally seeing some chance for that change. What he's asking for is simply humane tactics to be used. I would go further, but what we have today is something that is a great start. It is to prohibit excessive physical restraint. There is no reason to use excessive physical restraint in transporting a child to a facility. It is to ban nighttime extractions. There is no reason that a child should be woken from their dreamlike state and be brought into their worst nightmare by these agencies and these transport companies. And it establishes civil penalties for violations, which as a lawyer, I can tell you is critically important to ensuring the safety. Without civil liability, we have no recourse to get reparations for these children, and we have no recourse to ensure they're held accountable. So please, I implore you all to pass this bill and be in support of it. Thank you very much.
Thank you very much. Lauren Tenney.
Hi, thank you very much for the time to be able to speak today. I'm here today to ask you to support HB 497 with a favorable report. The fact that we're even debating legislation with the phrase preventing abduction and youth transport is horrific. A lot of this, I've submitted written testimony, so I just want to highlight a couple of things. A lot of this may already be addressed by CMS regulations around restraint. Particularly around the reasons why staff. So I think that there should be a full investigation into companies, whether or not this bill exists, that the legislature takes on. I also mentioned this the other day in supporting the Self-Directed Care Act to the Senate Finance Committee. But if the state of Maryland had an active Olmstead plan in effect and that there was a MIS committee, Most Integrated Services Coordinating Committee, a lot of these issues, even the issues with the debates that you just had around CPS, would be getting addressed at a broader way. We know for a fact that a hooded and shackled van ride from which someone else profits hardly seems to meet the Olmstead mandate. Prioritizing bodily autonomy, literally freedom of bodily movement, HB 497 would be an act toward fulfilling the Olmstead integration mandate's goal of promoting full integration and participation in the community for individuals with disabilities. We know that race, ethnicity, class, sex, gender, sexual orientation, religious, spiritual experiences, and other forms of disability impact court-ordered psychiatric involvement. Minors don't even have the right to consent to involvement with their treatment. So whether minors assent or refuse treatment is not even in their legal right. Marginalized communities, particularly those who are Black, Indigenous, people of color, LGBTQI2SA+ individuals, young people and senior citizens, and those experiencing poverty are disproportionately subjected to psychiatric treatment. This systemic violence and inequality is compounded by racial bias, classism, and lack of access to voluntary care options. So while I'll always approach psychiatry with a critical lens, HB 497 offers a real opportunity to immediately abolish some of these horrific practices that it's designed to outlaw. And so I would just ask one other thing. If this doesn't pass,
Briefly.
Not only does it represent a crisis for the conscience of the state of Maryland, but how should we tell young people that it did not pass?
Thank you. We'll hear from Lori Townsend, and then there are a number of questions.
Thank you.
2 minutes.
Good afternoon, distinguished members of the committee. My name is Lori Townsend, and I'm a tutor and proud resident of the state of Maryland, where I've raised my 5 children and I also enjoy the company of my 6 grandchildren. I'm also a member of the Citizens Commission on Human Rights, CCHR, which investigates patient abuse in the mental health system. CCHR has long been concerned with the alarming number of foster care children who are prescribed psychotropic drugs, particularly antipsychotics, both nationally and in Maryland. I raise this today to underscore the need to strengthen the bill. I commend and support this bill, but ask that it be expanded to include protection against chemical restraints. This would align with the Center for Medicaid and Medicare, which announced major changes in the long-term care surveyor guidance taking effect this month. Although relating residential treatment centers, it could be expanded to the transporting of patients. CMS defines chemical restraint as any drug that is used for discipline or staff convenience and not required to treat medical symptoms. Illinois recently took action to ensure that youth are not subjected to restraint during transportation services. The definition of restraints includes manual, mechanical, and chemical. This means the use of medications that restrict a youth's freedom during a behavioral crisis or emergency and is not a part of the youth's standard treatment. Survivors of restraints often face long-term emotional trauma, including nightmares, emotional numbness, angry outbursts, flashbacks, and difficulty sleeping. Chemical restraints can be even more harmful than physical ones, and I urge you to amend Section 8716 of HB 497 to include chemical restraints with clear definitions as I've outlined. By doing so, we can ensure that Maryland's children and youth are not subjected to unnecessary harm and that their rights to dignity and safety are upheld. Thank you for your time and consideration.
Thank you very much. We're going to take questions now, and we're going to start with Delegate Phillips and work our way around. Delegate Phillips, please.
Thank you. Thank you, Mr. Chair. And thank each one of you for coming to testify and sharing this with us. And like my colleagues, this is not something that I'm really familiar with. I have a question, and it was probably better asked of the sponsor. But if anyone can answer this question for me, I'd appreciate it. We're going after civil action, and civil action has a tendency to chill particularly corporations and businesses from doing certain things. But there are individuals that are involved in this taking, in this. Is anyone aware of any criminal statutes that might apply as a way of chilling not only the companies, but also the individuals? Is anyone aware of anything that is taking place across the country to address the people? It's not an assault if we've gotten some permission, and I think, is it okay if I?
Delegate Stewart, come back up.
I'm sorry, Delegate Stewart. I should have asked this earlier.
Okay. So theoretically, even if you do sign some sort of power of attorney agreement, that doesn't absolve people of just basic assault or torts or criminal assault. I think in practice, it's a lot more difficult to prosecute something like that. I'm not aware of any prosecutions that have ever taken place against any individual that's part of this industry, probably given the difficulty of doing that, especially if the parents are complicit in it. It becomes really complicated to prosecute. I mean, to your point, it is difficult to go after the individuals, and it may be worth looking into because in a civil suit, the company itself would say, obviously, they were acting in the course of their employment, and so they wouldn't be able to be, personally liable.
All right, this is a criminal act, and this bothers me, so we'll figure this out.
That makes at least two of us, Delegate Phillips. I appreciate it.
Delegate Schmidt.
Thank you, Chair. That makes three of us, Delegate Stewart. Four. There you go. We can probably go around the room here. I just want to thank each of you for coming forward to testify and work on this bill. I have a few questions here. Do we know how many states have passed this law?
One, Oregon. This in particular. Other states have, and actually, to the credit of organizations like 1111 and to people like Ms. Hilton, other states have taken actions to start regulating for the first time, just in the last couple of years, the residential programs themselves. We would become, with this bill, the second state to regulate the transport companies.
Gotcha. Okay, and then that leads into my next question. I guess it could be for anybody with 1111. Where do these transport companies, do they advertise? Where do you find these companies? I'm almost scared to Google it on my state laptop, but I just need, any information would be helpful.
Ms. Cole can go for it, I guess,
yes,
with the chair's
happy
permission.
to answer that question. Thank you. Fantastic question. So these companies, as Delegate Stewart had mentioned, they are national companies, and so they have gotten very savvy with the way that they market online. And so they use different SEO to be able to geo-target certain areas. And so if you were to, type in youth transport, in your state, you might get a company that's located in Utah or Montana or somewhere else, but the entire website is going to look like it's catering to Maryland families. And that's what can be very confusing for parents who are looking for resources if they're not aware of how these types of those types of marketing operate. And so generally that's the gist of it.
Yeah, and I'll add one thing, Delegate Schmidt, if I could, which is that one really pernicious thing, one of the most horrifying things that I read, and this is all kind of a house of horrors, is that a lot of the residential programs themselves will have kickback agreements, referral kickback agreements with the transport company. So in other words, if a parent is Googling which residential program they want to put their kids in, and then they put down a down payment for tuition at one of these programs, oftentimes that program will say, great, and the safest and best way to get here is through so-and-so youth transport company. Here's their number, and if you call them today and mention us, you'll get a 15% discount.
Wow. Wow, thank you. And do we know, Ms. Cole, how many kids or people per year are affected? Did you mention that earlier?
So we did not mention that. So right now with the data that we have, and data is limited, I will say that is a weakness of this, is because it is unregulated. There's just no reporting requirements that currently exist. But we see that there are about 120,000 to 200,000 kids every single year that are entering these facilities. I would say about a third of that is private placement. And then the other populations that make up that number are going to be through the child welfare system, through the juvenile justice system, and also through special education, specifically funded through IEP programs.
Gotcha. Thank you. Appreciate it.
Hey, thank you, Mr. Chair. This is for, I think, the delegate, but maybe for others as well. So is this bill specifically targeting the transport companies?
Yes.
So it does not matter, because I've heard some of the witnesses talk about the facilities.
Right.
So it does not matter where they're going, it's the how they're getting there?
No. So if you look in the bill, the restrictions on these companies applies only to companies that are transporting them to one of these types of facilities.
Okay.
And that's it. So if you're transporting, for whatever reason you wanted to transport someone to Disney World, then this bill would not apply.
Right. Okay. I knew that. I looked at it. So as we talk about not having heard of this, possibly not in this magnitude or going out of state, but we in Maryland, and I know it because as having been a school administrator, know that we have looked into group homes where some of the same behavior or treatment has happened. So it really is all around us. However, sometimes we don't pay attention to it because the children who are in these facilities are not children who are coming from wealthy homes, or that folks are not necessarily talking about them. So that's why I asked the question about the transportation, because sometimes they are not being moved out of homes with the kind of situations about which you're talking. Sometimes they are with some of them, but it's still local. So this bill won't cover them.
Right. That's right. And so Delegate Pasteur, if you want to work on legislation, with or without me in future years to try to regulate some of any of these types of institutions that exist in Maryland, I'll be right there with you. But we thought that the way to kick this off that would be the cleanest and easiest to get done this session was by targeting these transport companies, because I really think there is virtually no justification for what they're allowed to get away with right now.
And that is so, and certainly I'm not opposed to that, because we're seeing some of the same things happening, and it's done, however, on a more local level. As I said, we have sometimes, and we changes from time to time on addressing some of these group homes that really are not, and someone, I just heard someone mention through the foster care system, sometimes some very egregious things happen to our children when we put them in systems that are supposed to be taking care of them. And we don't really talk about how awful it is. And it's the same kind of things. Let's make sure that little Johnny stops acting up in class, so we have something for you, et cetera, et cetera, et cetera. So maybe this is a good start, but we need to also come in and embrace the notion that some of our semi-disenfranchised, more disenfranchised on different levels, are also experiencing some of these situations and the trauma that happens to them for a lifetime in the name of making them better.
For sure. Understood. Very well said. I appreciate that, Delegate.
Thank you, Mr. Chair. Thank you, Delegate Stewart, for bringing the legislation and for your very well-stated witnesses. In 2012, we actually, I sponsored legislation that made it impossible for anti-gay therapy camps to be allowed to perform in Maryland. And I would be surprised if any of these institutions, which would be analogous to that, not necessarily with that community, but could be all different kinds of communities, would be able to do their business in Maryland, which is great. But this transport shocks me. And it, I wanted to ask, I guess it was really for a witness. I don't know if you can choose which one, but it sounds like there could be criminal assault, could be appropriate, especially even if you're a parent. You can't handcuff your kids and throw them into cars. You're not allowed to do that, even if you're a parent, let alone a power of attorney. But one of your witnesses stated that you're feeling like you're being treated like a criminal. Actually, criminals have more rights than that. You can't do that to criminals, right? In fact, we changed the law on that. So I'm wondering if there's a comment about actually not feeling like criminals, but feeling like you're actually even lower than or less than a criminal, and who would be the appropriate person?
That's very well said. I mean, if anyone wants to
maybe just one person.
Yeah. Anyone virtually want to speak to that?
I'll speak to that. Yes, these people treat you worse than a criminal, and it was one of the most terrifying experiences of my life and something that I'll never forget. And this is just a service that these schools add on because it's just another fee for the parents or for the insurance companies or the states to pay. And there is no regulation, and the type of people that they hire for these positions are people who I really believe enjoy abusing children. And I've met several of them, and I was just a kid who was getting bad grades in school. I was sneaking out at night, and my parents talked to an education consultant, which is basically these people who get commissions from these types of schools and places, and then the transporting is another service that they add on because all these places care about is money and profit over children.
Thank you. Thank you.
Thank you, Mr. Chair, and thank you for coming to testify and for sharing your story. I had a couple questions. I don't know if this is pointed more towards Ms. Daughtry or was the woman here at the table. I guess the questions I have with regards to trying these cases, have there been any concerns? Well, one, have you ever tried any of these types of cases in Maryland? And have there been any concerns with trying these types of cases here in Maryland?
Thank you very much. I can speak to that. I have not personally tried one of these cases in Maryland. There's, as we've heard here, very few civil remedies available across the country. Just in Oregon and hopefully now in Maryland, there will be civil remedies available to hold these transport companies accountable. I have held accountable quite a few facilities and group homes that conduct within the troubled teen industry, and we've been successful to get reparations and actual change as well in those facilities. But the actual transport companies have gone without any type of repercussions. And that's why this is so important to pass this bill today.
Thank you. And I have one follow-up question. Are any of these transport companies located here in Maryland? Are we aware of any of them?
We're not sure about that, Delegate Williams, because if you Google them, they oftentimes don't have their, origin or their, I've tried to look up some of the business licenses, but there are so many of them, it'd be a very lengthy research assignment to try to compare all of them to SSTAT to see if any of them are headquartered here. So I'm not aware of that personally. And to your point too about prosecuting these cases, I mean, as you know, and as all the attorneys here and the whole committee, of course, given your subject matter knows, I mean, in order to start a prosecution, a lot of times you need a complaint. And who's making this complaint? Is it the parents? Probably not. It's going to take them years, if not decades, to hopefully realize the error of their ways. Is it the children who have been beaten to submission and who are now traumatized for life? Probably not. So I think that's why I tried to do some research in this. I couldn't find a single instance of one of these companies or any of the individuals who work for them to ever have faced any criminal or civil liability.
Okay, thank you.
Delegate Conaway?
Thank you, just to note, one of the witnesses on the panel has had their hand up. Did you want to acknowledge him? You want me to go?
Delegate Simpson.
Sorry. Okay. Thank you, panel, and thank you, delegate, for bringing this bill. My question is, when a citizen, an adult, makes a 911 call for a child in need of service because they may be acting out, what normally what can happen with that type of call?
When you make a 911 call, I think that goes a little bit beyond the scope of the bill.
No, it doesn't go beyond the scope of the bill, because I'm gonna tell you what happens. You can call like your juvenile kid is acting up. Maybe they have some activity going on that you don't approve of. You get into a heated debate or argument, and things get a little out of hand. You make the call, the ambulance will come, and the police will come. And if they see your child is emotionally upset or something, they are subject to take the child, handcuff them to the gurney or whatever you call it, and then put them in the ambulance and take them in for an evaluation. Are you aware of that?
Yes, I have heard those types of stories.
Okay, and are you aware that they're subject to put medication into the child's food?
I am not aware of that.
Oh, well, see, maybe I know more about it than you do, but I didn't hear anybody say anything. I heard the one lady, and I really appreciate about sneaking out at night, but there's other things that go on like carjacking, breaking and entering. Your child might be fascinated with fire, which they might be getting involved in arson, prostitution, and stealing. So we have to figure out a way to how to deal with this. Now, I understand that this seems extreme, and I'm not really for the putting the hood on the children, and I'm not for the handcuffing, but I've seen it being done. So, and that's in the medical industry.
Yeah, I mean, and to be clear, this bill would only apply to the transport to one of these programs. So if someone is being transported to a hospital or a legitimate therapeutic entity or a prison or anything like that, the bill would not apply. If the committee wants to broaden it to include those types of facilities too, again, that's your prerogative. The bill belongs to the committee now. But this bill would not apply to those circumstances.
I wasn't suggesting that we broaden it. I was suggesting that you didn't mention that this is what happens like when an ambulance comes.
Okay. And that's because the bill doesn't apply to ambulances.
Well, you made handcuffing a child seem so devastating, and that's what the nurses and doctors will do, or whatever you call them in the ambulance. But I thank you.
Okay.
Delegate Moon.
Thank you, Mr. Chair, and thank you for bringing the bill. I actually had heard of the troubled teen industry before, but not quite the angles that you're bringing. I have a couple questions, and first, I just want to piggyback off of what Delegate Pasteur was asking, which is, if we agree that it might be criminal behavior and certainly civil liability for some of the behaviors that we're seeing, zip tying someone, kidnapping them essentially, restraining them and holding them against their will, is there a reason that that's less offensive or illegal as to transport to this facility versus to any other facility?
No, not necessarily. So again, you always, whenever you draft a piece of legislation, you're trying to find some sort of happy medium between the ultimate outcome you want to see in society and the bill dying, and you want to try to find what the sweet spot is to get it passed. But again, if you guys want to take a larger crack at this and look at other facilities beyond these residential programs, I'm not going to be the one stopping you.
Okay, because I assume if they're taking contracts for transport, they're taking them for transport to various places, and this is just one of the destinations.
That's actually a good question. I think it depends on the company. Some of them are very specially targeted because they have lucrative deals with specific residential programs, and some of them probably are broader.
I guess I just don't want to pass a bill like this and then wake up to discover that there's multiple types of places these kids are being dropped to that are equally problematic. So somewhere along the road, if we could get some information on who the other options are where people send their kids, if you have it, that would be useful.
Yeah, I mean, we tried to be exhaustive in the definitions of residential program. You'll look, I mean, we had like 4 or 5 delineated types of things that we described. I mean, you can add a catch-all to that too, but I mean, I'm happy to.
Like if they're being sent to actually a drug rehab facility, I have similar questions about what's allowed and what's not allowed in that scenario. So my next question then, I guess first for the sponsor, and then maybe if anyone actually has attempted a civil suit who is a victim of the practice, I would be curious if anyone's tried to sue. But on that question, do you have any indication in what you've seen as to whether a parent can essentially waive the future claims or liability on behalf of their child?
That's a great question. That is actually a really thorny issue I've not looked into. Obviously, with these consumer contracts with these companies, you could waive a jury trial, you could, go and buy an arbitration, you could do all sorts of things. Whether that would bind your child may depend on the statute of limitations. It would probably start running when they were 18, but that's a good question. I'm not exactly sure whether you have the ability to remove their right to the courthouse through a power of attorney agreement.
So that's one I would definitely be interested in getting more information on. It sort of gets as to what this is actually going to look like if we end up in court, either with the claims that you're trying to allow in through your bill or through any existing claims they might have through ordinary tort law and existing Maryland law.
I mean, I would imagine that, if you're 14 and your parent subjects you to something with a power of attorney agreement, I don't think that other people can waive your constitutional rights through a power of attorney agreement. So I don't want to speak out of hand, but I think that they would still have a private right of action if we created one for them.
And then you sort of touched on my last question, which I know is a question on the bill coming up right after you, which is about the statute of limitations in a case like this. And, assuming it's going to normally run 3 years, I don't practice civil law.
Yeah, that's a great,
You're 14, some of the people here were 14 or 16. Are they running, are they extinguished at 17? You're saying it might run at 18, but then if they don't know to do this or sort of get their confidence together to file suit pretty quickly after this happened, I mean, are we, even with your bill, are they going to be out of luck?
Yeah, it's a great point. So I do believe the statute of limitations for something like this starts to run upon your 18th birthday, and there is no statute of limitations outlined in the bill. So it's a great point that right now that would mean that it would extinguish upon, when they're 22, basically, because it would be the default 3-year.
So I guess maybe we could just do this by a show of hands on the Zoom or in person. If you actually tried to do a civil litigation or sue in some way, could you raise your hand? Okay, so no one was able.
Oh, it looks like Mr. Harvey did think about it.
Well, again, the litigation that we've been involved in is against the troubled teen industry, not particularly the transport agencies, because there haven't been civil remedies available, and that's what I think Delegate Stewart is trying to do here, is create civil remedies. To your point, a very quick fix could be made to the bill to say that it applies retroactively, or that it applies regardless as to what time frame the transport took place. And I think that's a very important piece to it, because there are a lot of survivors who really haven't processed until many years after the trauma, and the average age of disclosure of this type of abuse or any type of assault is 52 years old. So to your point, I think that's important. That would be an excellent amendment if the Judiciary Committee were open to it.
Thank you.
Just so people know, Delegate Sample Hughes, then we're going to Delegate Simpson, then I'll go to Delegate Erican and Embry, and then we're going to stop. Delegate Sample Hughes.
Thank you, Mr. Chair, and thank you again for the opportunity to ask another question. I want to ask you about the financing of this, because we talk about that money is part of the driving factor. And when I was doing some research, some of the information showed that the cost may go anywhere up to about $6,000 just to do the transport. And it was whether it was through a vehicle or air, even private air, if they wanted to transport their child that way. So my question is, are you aware, is it just strictly private pay, or are we at any way involving Medicaid or any other insurances that are being used for this transportation service that we may have some jurisdiction over?
Yeah, it's a great question. I'm only aware of the private pay, and you're right. The numbers I've seen are $5,000 to $8,000, not including any plane travel for this. If anyone on the Zoom or anyone behind me knows if any states have ever been on the hook for this kind of service to transport anywhere, I'd be interested to know that. I have not heard that, but it also wouldn't shock me.
I think it's necessary that we figure it out, because if we're talking about what we can do, then I don't want to be in a position of a lawmaker utilizing Medicaid funds to transport a child in this manner. And we're talking about IEPs, we're talking about the foster care system, and all of those areas where it very well could have funds for us to support this. So if you could find that out, that would be great.
Yeah, no, I will certainly try, and I think it's a great point, and I think it's something that another simple and very positive amendment would basically be prohibiting the use of state funds for the kinds of behavior we're making illegal for private companies, right? I mean, obviously, if we made it illegal for them to operate in Maryland, then presumably that would apply to whether it's private pay or public pay, right? But making that more explicit in the bill is also something that could be a good idea.
Okay, and the persons you had testify, I don't know if they know whether or not their parents paid just with a credit card or if it was through insurance. Maybe that could be the starting point.
I mean, I think, yeah, maybe Ms. Cole.
Ms. Cole has raised her hand.
Oh, okay.
Thank you. And I did want to speak to that broader federal issue of public dollars. So actually, just this last Congress, there was a bill that was passed called the Stop Institutional Child Abuse Act. And in that bill, it asks for a thorough accounting of those funding streams that goes into the placement of these children. One of the things that we discovered throughout the course of this particular bill is that on the federal level, either through Medicaid or Title IV-E dollars, Title IV-B dollars, adoption subsidy, I mean, just the list goes on, is that there was not a thorough accounting of how those dollars were being used. And on the federal level, we saw them paying up to $10,000 to $15,000 a month to place children into these facilities. So I do believe that transport of these kids very well could be a part of that total cost, but that is something that is currently being fleshed out on the federal level.
Okay, thank you very much. Thank you, Mr. Chairman.
Delegate Simpson, virtually getting better at home, we hope. But is on mute, so we can't hear her. Try again.
So I am familiar with these programs. I do know of, I mean, they're now an adult, but they were like 10 years old when drugged by their parents, taken to a military / mental health in another state. So, and with the parents agreeing to like an 18 months to 2 years time that they were going to fix their kid. So how do you anticipate this to work? How will this help?
Oh, sure. Yeah, well, that's kind of a softball. I appreciate Delegate Simpson. I hope you're feeling good. So how I would intend it to work is that through both the AG enforcement provisions in the bill and the civil liability that we're opening up in the bill, none of these youth transportation services that currently do operate in Maryland with impunity would feel comfortable doing so anymore. They would stop because this bill strikes at the core of their business model, which is midnight, early morning kidnappings, bindings, blindfolds. That's how they all operate. It's all standard operating procedure. So by striking at kind of the core business model and how they operate, with both AG and civil liability, including attorney's fees, the hope would that they would pack up and leave, and we would never see them in Maryland again.
Do we have a list of these organizations? Like, do the AG, do we know where we're going?
I can find you probably a list of the top 5 or 10 just from Googling them, but that's not something that the state or the federal government currently tracks. I think there's also a little bit of a whack-a-mole element here where sometimes if a company gets some bad press, they'll close down and they'll open up under a different LLC name.
Exactly. It's very needed. I just worry how much we're able to do since it's with the parents. Who else can bring this to bear while it's happening? If the parents are agreeing to this, it's like, who else can say, hey, this is happening?
Well, right. So, we would hope that, to Delegate Moon's point, that years later, the prospect of years later civil liability on behalf of the child, once they can sort of hopefully get over some of that trauma, the fact that they could potentially be sued for massive amounts of damages with attorney's fees, even if it is 5 or 10 years later, will prevent them from acting that way then. Also, by bringing in the AG, we're hoping that the AG could sue and maybe get an injunction or some sort of equitable relief sooner. Now, how would the AG hear about it? Well, hopefully there are other people in the lives of the parent or the child, from educators or friends or neighbors, who could alert the AG if they heard something like that was still taking place in Maryland.
It's a good start, but I agree. It's one of these things that until kids are safe, until they're probably and obviously if their parents are agreeing to have them go and be shipped somewhere, the time that it gets to them being safe could be so much longer.
Yeah. I would hope, right, that obviously these transport companies wouldn't operate if we explicitly make these tactics illegal and we put them on the hook for massive civil penalties. That said, I also am not going to sit here and say that this bill is the panacea that's going to solve the entire troubled teen industry in Maryland. This is the first start. This is one of the only bills like this that's ever been introduced in the United States. But it sounds like there's a lot of interest on the committee about maybe making both this go further and also looking at other legislation in the future. And that's really exciting. And I look forward to working with you guys to take as many steps as we need to kill this industry for good.
Okay. Delegate Simpson's picture is frozen, unfortunately. Delegate Erican.
Oh, my. That happened to me yesterday. Okay, so after Ms. Cole spoke about the state monies, and we've had a couple people touch on it, we absolutely have to know if our state is spending money on this. I want to know that. I want to know it as soon as possible, because that is definitely an avenue for us to just cut it right off. So if you get that information to us.
Yeah, we will get into that immediately once the hearing is over. I agree with you 100%. It's a terrifying prospect that we could be using tax dollars for this kind of abuse.
Super disturbing.
What I will say is that the bill, I think, will fix it, right? Because whether it's private pay or public pay, we're not going to have the transport companies come in either way, but we should know immediately.
Yeah, especially since we could be open to liability.
Well, right, and in terms of emergency bills or other things that we could do that are faster than the effective date of the bill, so yeah.
Yeah, awesome, thanks.
Thanks.
Yes, thank you, Chair, for letting me ask another question. On the issue of liability, I noticed the bill includes restitution, which I read as just economic compensation. Would you be willing to consider non-economic, because it sounds like the real damage to these kids is...
Yeah, I interpreted restitution as including both economic and non-economic.
I think we might want to...
When I read it, but it is not totally clear to me. I think that opening them up to economic, non-economic, reasonable attorney's fees, and maybe beyond, right? Are punitives, should we make punitives explicitly open? But yes.
I would support all the above.
Yes, but certainly I think making clear about exactly which damages are recoverable, I think would be a crucial amendment. I'm 100% supportive of that, because we really do want to spook these companies, right? Unless they're going to be on the hook for real damages, then they'll probably just continue operating, hope they don't get sued, and anytime they do get sued, settle as just an ongoing cost of doing business.
And can I make one more suggestion in this line? I think that the language about training, adequate training, might not be enough. I just feel like that they could say, well, we do some in-house.
Right, I
just
know.
wonder if you want to think about.
Yeah, we
keeping that up.
thought about that too. You know, we even tried to like look to see if there were any like national standards or training that we could specifically spill out of the bill and just kind of, instead of like just using a throwaway of adequate training, and we couldn't really find anything. But I mean, not to give the committee endless homework here, but that is something that I think you're right, that is worth looking into.
Thank you, Chair.
Okay. We're done with this panel. Thank you very much. We have one more person to testify on this bill, and Delegate Crutchfield has been very patient. Leslie Margolis from Disability Rights Maryland. Is she virtual? No, she's there? All right, Ms. Margolis, you can testify for 2 minutes, please.
I'm sorry, did you just call me Leslie Margolis?
I did. You can testify for 2 minutes. Go ahead.
My computer is connecting. Good afternoon, Chair Clippinger and Vice Chair, members of the committee. It has been really heartening to hear all of this testimony. My name is Leslie Margolis. I am a managing attorney and policy counsel at Disability Rights Maryland, the protection and advocacy agency for the state, as well as co-chair of the Education Advocacy Coalition, a group of almost 50 organizations dedicated to education policy and children with disabilities. We support House Bill 497 with amendments, and there was a reference to our amendments by Delegate Kaufman earlier. Essentially, we have proposed, our amendments are outlined in our written testimony, but essentially what we are trying to propose is taking the restraint seclusion requirements that are currently contained in the Maryland Education Code, which was most recently addressed by the General Assembly in 2022. It's our position that mechanical restraint, the use of chains, irons, straitjackets, handcuffs, hoods, zip ties, any item used to restrain a child should never be used. Not in residential programs, not in schools, not during transportation, never. So our amendments propose completely prohibiting the use of mechanical restraint and allowing physical restraint when a person's actually holding a child only if the child poses a substantial likelihood of imminent serious physical harm. In the education context, that is risk of death. It is risk of loss of a bodily function, extreme pain. It is a very, very high standard to meet. And we are proposing that that be the standard. This bill does not reach what happens to children once they are in these residential programs. And I would note that we have deep, deep concerns, particularly about the use of out-of-state programs by the Department of Human Services when placing foster children. They're using programs that are owned by private equity, for-profit firms that have been, were the subject of a scathing report by the United States Senate Finance Committee, and Maryland has used a number of these placements. But what this bill does is begin to get at addressing the troubled teen industry through transportation, and that is a very good start for protecting Maryland's children. We're happy to work with all of you on refining language. Really pleased to see the suggestions to strengthen the language. We would welcome the opportunity to work with you to make this bill as strong as possible to protect as many children as possible. And I'm happy to answer questions. Thank you.
All right. I don't see any questions, but thank you very much. That concludes the testimony on House Bill 497. Thank you very much for everyone testifying. Now, back to regular programming. We're going to House Bill 533. It only had 4 witnesses, so oh dear. But Christopher Arnold is virtual.
Okay.
Lisa Jordan. Laurie Ruth, is she here?
She's across the street, Mr. Chair.
She's across the street.
For her.
All right. Delegate Crutchfield, I understand you like white wine. Yeah, partial to red. Okay. I've informed Delegate Stewart. All right. Please,
all right.
Crutchfield.
Thank you. I'm back. Last one. Last bill for me. Okay. So for the record, I'm Delegate Charlotte Crutchfield, representing Montgomery County's District 19, and I'm here to testify on HB 533. And this is dealing with peace orders and protective orders for military protective orders. This legislation really is going to provide some continuity between those victims of domestic violence, harassments, threats, who actually get a military peace order. And what it does is it's going to provide the ability for them to now have some protections outside of the military installation. That is what this bill really does, is it helps to provide that continuity between being on military installations as well as being off a military installation. So it does that in two ways. Maryland judges will be able to consider the already existing military protective order when they're actually considering, again, some additional relief for that victim that already has a military protective order. It will also provide for the ability for the civilian law enforcement to be in contact with military law enforcement whenever there is probable cause to believe that there has been a violation of that military protective order. That is what this bill does. Again, continuity between being on the military installation and being off the military installation. So what I'm going to do is I'm going to turn it over to my panelists next. And again, one of the other things I think I need to point out is you must understand that currently, under current law, okay, the military protective orders cannot be enforced, all right, outside of the military installation. So that is part of the real issue here. And so in this bill, again, it provides that continuity so people feel like they can be protected off the military installation. So for those reasons, I would request a favorable report on HB 533. So I'll turn it over to my panelists next.
Good afternoon, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We are here in support of House Bill 533. It's my pleasure today to also be representing my colleague, Lori Ruth, who represents the Maryland Network Against Domestic Violence. She is across the street in JPR. And also Joyce King from the Maryland State's Attorney's Office asked me to chime in and say that they are also in support of this bill. Delegate Crutchfield, thank you for your leadership, and thank you for also doing such a thorough job of explaining the bill, leaving me just with the task of describing some of the reasons we need the bill. Because again, military protective orders are not enforceable by civilian authorities, which kind of makes sense from an enforcement point of view, but for a survivor, they often don't realize that. So we had a sexual assault case. There was a military protective order. After the case was charged, the defendant kept driving in front of the victim's house to intimidate her. The military protective order didn't stop that. She would have had to go and get a civil protective order. A domestic violence case where the incident happened on the post, the victim then moved off the post. If the military protective order was in place, the victim, she had a military protective order, and the victim called 911 because the abuser was following her. But she was now off base. And again, the military protective order can't be enforced by the civilian authorities. And then finally, we've got a stalking case where there was a military protective order, but no civil protective order, and the defendant broke into the home. If there was a civilian order, you would have had a violation of the civilian order as a separate charge. That couldn't be enforced because it was a military protective order. This doesn't completely solve every problem, but it does increase communication. It lets the civilian court consider the military protective orders, and it also means that if civilian authorities find out about a violation, they will tell the military. For these reasons, I ask for a favorable report on House Bill 533.
Thank you. And Mr. Arnold?
Thank you, Madam Chair. Christopher Arnold, Mid-Atlantic Region Liaison at the United States Department of Defense State Liaison Office. Military commanders issue MPOs, their stay-away orders, requiring that members stay away from victims of alleged abuse or harassment. And as the delegate pointed out, they're only enforceable on the base, which creates a dangerous gap in protection when the service members are off base, where they spend most of their time. 2/3 of our families live off the installation anyway, so Some judges may mistakenly believe that an MPO provides sufficient protection and hesitate to issue civilian orders, which leaves victims even more vulnerable when they're off base, which is where they spend most of their time. So this legislation addresses the gap in two crucial ways. Allowing the judges to consider the existence of an MPO gives them important context about patterns of concerning behavior, and the required notification between law enforcement improves coordination between civilian and military authorities. So this bill closes the dangerous jurisdictional gaps that abusers exploit. When a victim musters the courage to get protection on base, that protection shouldn't vanish the moment they step off of it. So thank you, Delegate Crutchfield, for bringing this common sense measure to help protect military families who are victims of sexual assault and domestic abuse while improving coordination on behalf of the Department of Defense. And as always, I stand ready to answer any questions you may have.
Great, thank you. Are there any questions? I have one question, and that is, and it may be in testimony, I was just digging to try to find it, but I think my question is for Mr. Arnold. And I wanted to know, and of course, Delegate, if you have the answer, feel free. But I wanted to know if other states, if you have a type of compact, this type of agreement with other states.
Thank you, Delegate, for that excellent question. So this item became a Department of Defense state policy priority last year. Several states, including Texas, Iowa, Illinois, Maine, and California, took action in the first year. In the second year, in my region alone, Virginia, it's already passed both houses. Maryland, we've passed the Senate. Delaware, the bill was just introduced. West Virginia, it's coming a little bit, later in the session, and also expect to get it across the finish line in Pennsylvania.
Great. And are you all, is the Department of Defense also working in DC on a federal bill? Or do you not have that jurisdiction to be able to do the federal? Well,
yes,
no,
ma'am. So
sure.
where our office sits, we do intergovernmental relations with the states, and the Assistant Secretary of Defense for Legislative Affairs handles interagency and the Congress. So there's kind of a walled garden between the two of us, but I'm happy to refer you to them and get an answer for you if there's any congressional action in this space.
And Delegate Crutchfield, did you have anything you wanted to add?
No, I do not.
Okay, thank you. Delegate Conaway?
Thank you, panel, and thank you, Delegate, for bringing the bill. For Mr. Arnold, if a person has the military order against them and they violate that on base, do they go to the brig?
Delegate, thank you for...
If they're arrested by the MPs?
Delegate, yes, if they're arrested by the MPs, for sure. So as you know, there's, sort of the wheel of jurisdiction. You have, CID, you have security forces. Sometimes you have civilian law enforcement. Depends where, the installation you are and what the jurisdiction is and who the responding agency is. But certainly the penalties can include, being sent to the brig, for sure.
Sure. Now, if the incident happens, if they violate the order, the military, they wouldn't violate the military order, but if they continue that abusive behavior off the base, would they be required to go to the brig or would they go to the local jail?
Copy. So currently, if a person is violating an MPO, even if it's reserve or guard over a drill weekend, let's say, right? It only applies at the armory, and then you go back to the hotel. That order, while it's a lawful order, is not enforceable off the base. And really, without Delegate Crutchfield's bill, there's no way for the commander to even be aware that the order was violated. So Delegate Crutchfield's bill is going to close that.
Yes, that's true, unless it's on federal property. You didn't mention that. Is Washington, D.C. federal property?
So yes, the city of Washington, D.C. is federal property. Yes.
Is Baltimore Washington Parkway federal property?
So without knowing whether or not
I do know it is.
Was retroceded, the state may have concurrent jurisdiction over certain adult offenses if the jurisdiction has been offered and then the state is accepted.
Okay, and why don't the judges make their ruling broader if there's a military order?
So are you saying, do judges currently contemplate the MPOs without the existence of this legislation? Some may, and some do. I believe the advocates might be able to speak more precisely to that, but they may not know that they're allowed to consider them.
The judges may not know that they're allowed to. Okay, thank you very much.
Thank you very much. That concludes the testimony for House Bill 533. Thank you very much, Delegate Crutchfield.
Thank you.
We're going to move now to Delegate Spiegel. House Bill 456. And Delegate Spiegel, would you like to have favorable with amendments with you?
Yes, please, Madam Chair.
Okay, so we have James Van Hout. We have Sarah Sample. Oh, there she is. Okay, Delegate Spiegel, whenever you're ready.
Thank you, Madam Chair, members of the committee.
And one more thing. Is this your first time in the committee, this committee?
It is, Madam Chair.
Oh. And let me just tell you that we do have a 3-minute for our bill sponsors, and everyone else has 2 minutes. So whenever you're ready. Thank you.
Understood. Thank you. We handle first-time testimony in the Appropriations Committee a little bit differently, so I like this way better. Madam Chair, members of the committee, for the record, Delegate Ryan Spiegel in support of House Bill 456, which would extend the statute of limitations for civil claims of non-sexual child abuse. In other words, instances of physical abuse and neglect of children that are not sexual in nature. And as you well know, the Child Victims Act of 2023, also known as the CVA, removed the statute of limitations for civil claims of child sexual abuse, but the law did not impact claims for non-sexual abuse, which continued to be barred after a victim turns just 21 years old. And as Delegate Moon actually noted earlier, that may well end up precluding civil cases arising from the horrific abductions addressed by Delegate Stewart's bill that you all were discussing earlier. I'm sponsoring this bill at the request of a constituent who is a survivor and who has courageously come forward to share his story and to advocate for victims of physical abuse and neglect in Maryland. And of course, he is hardly alone. We should be supporting justice for all abused children, not just those who were sexually abused. As timing would have it, in just the last couple weeks, there have been a number of important developments that weigh on this issue. First, as I'm sure you know, the Maryland Supreme Court ruled that the CVA is constitutional and that there's no issue with changing the statute of limitations for child abuse claims. Secondly, as reported in the Baltimore Banner on February 3rd, Maryland has seen an alarming rise in child deaths from abuse and neglect. Maryland's rate is reported to be among the worst in the nation, and that's just the deaths. It doesn't include the terrible abuses that children have survived. Finally, DLS recently warned of a potentially enormous liability to the state from CVA claims that we've all heard of. In light of that concern, and given the state's current budget challenges, we have a sponsor amendment to cap the total cumulative payout that the state and local governments would be required to make on judgments in child abuse cases in any given fiscal year. And that would balance giving survivors their day in court while also ensuring that the state is not exposed to too much liability at once. I also want to emphasize this bill does nothing to change the elements of a cause of action or the burdens of proof for a civil claim of child abuse. Existing Maryland law already does allow these claims. This bill merely gives claimants the time they need to process their trauma, understand what happened to them, and put together a civil complaint by the age of 38 if they so choose. It also precludes claims of neglect against a caretaker who lacks the means to provide for basic needs, such as an unhoused parent. And ultimately, it will still be up to a judge or jury to determine if a claim warrants a judgment at all, and if so, how much up to the statutory cap. So I ask for a favorable report to give victims of non-sexual abuse a fair chance to be heard in court the way that victims of sexual abuse now have. Thank you.
Thank you. And whoever wants to go next.
My name is James Van Hout. From 2004 to 2009, when I was 9 to 14 years old, I was severely physically and psychologically abused and neglected at a school in Montgomery County called the Heights School. The school was run by an extremist sect of the Catholic Church known as Opus Dei, an extraordinarily wealthy and influential organization with ties to the government of the former Spanish dictator Francisco Franco. Opus Dei operates mostly independently from the rest of the Catholic Church, and in the past several years has faced widespread accusations of international child psychological abuse, child neglect, and child trafficking. During my childhood, I attended 5 Catholic schools in multiple states and Washington, D.C. The only Catholic school at which I was so severely abused or neglected was the school run by Opus Dei in Maryland. For the record, I attended the Heights School after my name had been changed from James Bogus to Frank Overcash, but before I later changed it to James Van Hout. As a result of the abuse and neglect I suffered at the Heights School, I developed severe depression, panic attacks, OCD, and PTSD, diseases which I have lived with for about 15 years. I have been discriminated against while trying to get a job, and I'm currently unemployed. At one point, I could not even afford therapy. For nearly 15 years, I could not discuss what happened to me at the Heights School due to PTSD, a phenomenon strongly supported by the scientific evidence. In fact, when I was 21, the year that the statute of limitations period expired, I fell into the most severe depression of my life, and I was hospitalized for nearly 3 weeks the following year. The Constitution of Maryland guarantees every person the right to sue. This right, alongside the unequivocal scientific evidence, is why you passed the Child Victims Act 2 years ago. The rule of law requires that the law be applied fairly to everyone, and justice requires that no one, no matter how wealthy or powerful, be permitted to offload the consequences of their actions onto others. Yet I'm speaking to you now because neither justice nor the rule of law have been upheld, as victims like me have been deprived of a constitutional right and effectively locked outside the courthouse doors. Therefore, I ask the General Assembly to uphold both justice and the rule of law by passing House Bill 456 with the amendments introduced by Delegate Spiegel, along with those I will suggest today. Thank you for your time.
Thank you. Ms. Sample?
Thank you to the chair, members of the committee for having me today. My name is Sarah Sample. I'm here on behalf of the Maryland Association of Counties, and we support with amendments House Bill 456. We've been speaking with the sponsor of this bill about some of our concerns, and I'll just go ahead and highlight them. So we absolutely appreciate the intent of this bill. Our concern is just we're looking ultimately to see sort of like a waiver of liability for good faith actions that are taken by some of the individuals who are staffers in some of these instances where we're interacting with children. To give you an example, we might have a Parks and Rec Division staffer who needs to intervene physically in a situation to either protect the kid, maybe protect other kids in the situation and or other staffers. And we would like to make sure that that individual feels like they can take the actions they need to protect the environment that these kids are in. The other concern was with mental injury. Again, like a staffer who could be working with kids in one of our Parks and Rec divisions, we might have an instance where they need to apply appropriate discipline to get a kid to be redirected or to get them back on track. And we just want to make sure that there's some acknowledgement for those situations in terms of a waiver of liability that would have to do with that. But other than that, we did see the amendment that had to do with sort of some predictability in terms of the costs and capping. I think it's the counties at, 0.5% of their operating budgets. We appreciate the sensitivity to the cost concerns. That was not the majority sort of concept in the written testimony that I submitted, but we appreciate that. There are some sort of practicality concerns in terms of, maybe that creating a logjam, maybe that creating a situation where some individuals are able to recover full damages, and then you have others that are waiting years to get their full pay up to $890,000. And so there's some concerns that our attorneys have raised from that perspective, but we absolutely appreciate amendments that are sensitive to the costs associated with it. But so those are our thoughts, and that's why we support with amendment on House Bill 456.
Thank you, and thank you all for your testimony. And Mr. Von Hout, thank you very much for sharing your story with us.
Of course.
It takes bravery, and I'm, very grateful for you being here today. I have a question for Ms. Sample. Do you have any examples of the types of discipline you were talking about with respect to Parks and Recs?
So when you, when I meant discipline, I was concerned about the term mental injury. And so if you've got, someone who's managing something on a sports field or in a gym, and you're trying to redirect a kid that's maybe not necessarily following the rules or the guidance or engaging properly, we want to make sure that they're able to take the actions that they need to try to get that individual back into sort of the program that they're on at that time. So that's sort of what I'm concerned about is will that action that they take, appropriate discipline, will that be mental injury? I don't know that that's clear in the bill.
And I don't know that it's clear in the amendment. Delegate, do you feel like you define that anywhere?
Madam Chair, I think the intent, and I assume it's reflected in the bill, but if it's not accurate, we can certainly provide some additional sponsor amendment language. But the intent is really to borrow from existing definitions elsewhere in the code regarding physical abuse, neglect, and mental injury that sort of already exist as causes of action, not to create new causes of action that have never existed before.
Okay, so perhaps you might be considering a definition of mental injury, and if there is one in the statute, you'd be amenable to referencing it as an amendment.
Absolutely.
Okay, all right, thank you. I see a few lights. Delegate Kaufman and then Delegate Conaway.
Yes, I have a question for the sponsor. As they did with Chair Wilson's bill, the Tort Reform Association is testifying against your bill, and they make it's a long letter, but they make 2 points. They state that businesses and that your bill would make it harder for businesses and for citizens to rely on the laws if they're constantly changing. And they also say, and I'm a proud co-sponsor of the bill, by the way, so I wanted to give you a chance to respond. They also say, if you're going to do this, Delegate Spiegel, make it prospective. And so I wanted to see I mean, I do admire their consistency on these issues, and so I wanted to see if you had any comments or sort of a pre-buttal, if you will.
Thank you, Delegate Kaufman, and thank you for your co-sponsorship of the bill. First, let me say to the broader point about any change in the law creating uncertainty, I mean, certainly that's an argument you can make about every bill that we introduce in Annapolis. So I'm not sure there's a lot of credibility to that, given that we have changes in the law all the time when we find that they are justified as a legislative body. Secondly, we are really trying to track essentially the terms of the 2017 precursor to the CBA. We believe that at this point, since this is not something that was included in the 2023 CBA, that it makes sense to take an incremental approach with these non-sexual abuse claims. And so we are seeking to have this sort of same model that was applied in 2017. Yes, retroactive, but only claims that can be brought up to the age of 38. And if the bill passes in some form similar to that, there can be a further discussion down the line about whether that should be extended or made more similar to the version that is reflected in the 2023 CBA, which of course has no cutoff for the statute of limitations. We tried to avoid that for purposes of this incremental approach, since this is the first time we're sort of raising this as something that should be treated equitably compared to sexual abuse claims.
Thank you. Thank you, Mr. Chair.
Delegate Conaway?
Thank you, Chair. Thank you, Delegate. Coming in to testify. Can I ask, what would the cap be for the year? What's the amount?
The amendment we've drafted.
Yes. Did you submit the amendment?
We did.
Okay.
Hopefully you all have it. It proposes for the state, the total of all state agencies in any given fiscal year, $50 million. So that's a cap. So we could agree to make it much lower if we decide we want to do that. If you all decide you want to do that, the bill belongs to you all now, of course. But the idea there was to simply say, you know, it's not going to be anything above that.
Yes, I understand.
And so
I've raised the tort claims cap before.
Yeah.
So you said that would be for the state.
That's for the total cumulative amount. So if 1,000 people brought claims and each of them had, you know, $1 million claim or something,
right,
the state would not have to pay out more than $50 million max in a year. And of course,
I understand that. I'm trying to move forward.
Sure.
So we heard testimony about the Catholic Church, and I happen to have gone to Catholic school. Many people don't know that, but would the Catholic Church be liable potentially based on the testimony?
Yes, potentially.
Okay. And you were here for the previous testimony on 497 because you made a comment about Delegate Moon's comment. Is that correct?
Yes, Delegate.
Okay. So under this, would the parents be liable up until the age of 38? Could you bring a civil action against your parent?
If you could have brought a civil action against your parents up to the age of 21 under existing Maryland law, then yes. But again, I just want to emphasize, as you well know, Delegate, this would have to go to a judge.
I didn't know, so go ahead.
This would have to go to a judge or jury, and,
Okay.
they would have to decide whether there's a real claim there or not.
Okay. Suppose if you thought that your parents abused you by sending you to military school when you were younger, like McDonough used to be. Could you bring a claim against them, a civil action claim? Under your bill?
Delegate, anybody can bring a civil claim.
I'm saying under your bill.
Anybody can bring a civil claim for anything, but.
Okay, so you don't want to answer that question?
Well, the answer is yes, someone could bring a claim.
Thank you.
Seeing no further questions for this panel, thank you all very much. We'll hear now from Carrie Silverman in opposition.
Thank you.
Sure. Mr. Silverman will have 2 minutes, and we will move to our last bill. Mr. Silverman, please.
Good afternoon, members of the committee. Mr. Chairman, my name is Carrie Silverman. I'm here on behalf of the American Tort Reform Association. I want to thank Delegate Kaufman for giving a little preview of my testimony and for reading it. Our concern with this bill is not its extension, its creation of a new lengthier statute of limitations for these types of claims. That's your prerogative to make, and perhaps the period is too short as it is. Our concern with the bill is its retroactive application. Statutes of limitations and reviving time-barred claims, by reviving time-barred claims, it undermines the stability, the predictability of the civil justice system, the ability to rely on the law. In this instance, what reviving time-barred claims does is it subjects a broad range of organizations to liability exposure stemming from their hiring and supervision of employees or volunteers based on what happened decades ago, and subjects them to questioning the adequacy of their policies and practices that they may no longer be able to dig up, have witnesses available to testify on all these many years later. The legislature may find that for some civil actions, a longer statute of limitations is necessary. And those changes should be made, in our view, prospectively. And they give notice to organizations that make decisions based on them, such as what length their records retention policy should be, what amount of insurance they need to have, and even decide whether they want to engage in providing a service or a product here in Maryland, given the level of liability exposure involved. And when this committee considered the Child Victim Act, ATRA expressed these same concerns and expressed concern about the slippery slope that we head down toward in reviving time-barred claims there, given the many other areas where there are these types of unresolved wrongs out there and where organizations will have difficulty defending themselves. This opens the door to billions of dollars, as you know, of liability, not just for the state, but also for other organizations that serve children. And we believe that if you are to move forward in this claim, we ask that you amend to eliminate the reviver for all public and private entities.
Thank you very much. Questions? Seeing none. Thank you very much. That concludes the testimony on House Bill 456, the last bill, House Bill 522. I have one person testifying here, and that's Delegate Taveras, and then we'll have Kia Savage virtually, who is on and will be joining us. Delegate Taveras, you have 3 minutes on the bill, House Bill 522.
Thank you, and I recognize I'm the last person between you and the door, so I'm sensitive to that. Thank you, Chair Clippinger and Vice Chair well, Bartlett, who was here, and committee members. I'm here to ask for your favorable report on HB 522, Department of Juvenile Services, Rehabilitation Services funding. This bill is part of a comprehensive package of bills to address youth substance use disorder of fentanyl. HB 522 ensures that youth under DJS custody and are struggling with addiction are able to stay in a residential rehabilitation facility for up to a year. The Department of Juvenile Services has the funding to cover treatment if the youth is under their custody. In addition, the amendment presented requires the existing Commission of Juvenile Justice Reform and Emerging Best Practices to provide an ongoing review of the evolving needs of youth who require substance use treatment. The purpose of this bill is to provide a continuum of care to children under their custody and assess whether our process provides the best return on investment. Many of these children who are admitted to DJS facilities are high school dropouts, unhoused, uninsured, underinsured, and in need of long-term residential substance use services. Given the lack of limited youth beds in the state, this proposed legislation would allow for out-of-state services as well. By providing timely long-term residential rehabilitation services, it gives young people a chance to reclaim their futures and re-engage with their education, giving them a pathway to stability and eventual healthy self-sufficiency. Substance abuse among youth is not only a personal health crisis, but also a significant factor in truancy and delinquency. Statistics show that students struggling with substance use are 2 to 3 times more likely to skip school, which often leads to involvement with the juvenile justice system. This is why early intervention is so critical in breaking the school to prison pipeline. HB 522 represents a vital step towards protecting at-risk youth and providing them with the tools they need for a better future. Thank you for considering this measure, which prioritizes the well-being and potential of our state's most vulnerable children. I ask this esteemed committee for your favorable report on HB 522.
Ms. Savage, for 2 minutes, please.
Hi, good afternoon. My name is Kia Savage, and I thank you for allowing me to have a moment to share my story. In late 22, I discovered my daughter, Jordan, had in fact been experimenting with drugs during an investigation in my home. This changed the trajectory of my life, but with great challenge. I was a single parent and I lacked familial support to help me figure this out. In November 2022, one morning I found my daughter unresponsive and was totally unsure why. It was due to an opioid overdose. I had to perform CPR for the first time on a live person. I had been certified in CPR for over 16 years at that point. Jordan was given Narcan and she survived, but sadly she died April 20th, 2023 from a fentanyl overdose. This experience led me to learn more about the services that were offered in my area, how difficult they were to receive. There are not many places that offer services to children with substance abuse as there are for adults. I did find a place in Baltimore City and I drove my daughter there. While on the phone with the facility, they reassured me they had available space for her in the program. We were the first people there seen at the clinic, and I was hopeful that she would be seen and that she would receive treatment. After going through a full intake and meeting with the clinician, they reported to me that in fact they did not have a bed available for my daughter in the inpatient rehab. That was disheartening because we lived an hour away. There were no other options available in our area, so I tried the next best option, finding therapy services. This was difficult because there was always some issue before me. If it was not an issue with her insurance being accepted, then it was a lack of openings. I became very frustrated and scared of the fact that my child was dealing with substance issues and my hands were feeling tied. This experience led me to really understand how disenfranchised I was as a single Black parent. My mother with the need of and a lack of resources. The resources available to me were far beyond my reach, and I wish there were more resources and awareness available. I look back and I wish I could have done more to prevent or prepare for this situation. My child's school did not even have many resources to offer. My daughter was involved in a minor incident which the police were called and she was referred to the Department of Juvenile Services. I advocated for my daughter to be given random drug testing and monitoring because I knew that she had a drug use as the root issue. I was able to get my daughter into outpatient therapy clinic. This was promising. We looked forward to it. Everything was set. She was even feeling great about going and sorting her issues. My daughter's case manager with the Department of Juvenile Services helped secure these services. She was found dead from a fentanyl overdose about 6 days before the first appointment. I was devastated, but also riddled with so many feelings. My life definitely has not been the same. I wish there was something I could have done. I often wish I were more affluent and I could have afforded to pay for my daughter to receive services. I'm not sure if any of these services would have saved her from her affliction, but I often do wish preventative measures could have been given to us. I look back on the very beginning and I just try to sort out how did it even get to that point? What could have been done different? And I hope I can learn some way to educate or support other parents to prevent the loss of another child. I hope that one day I can use this event that changed my life to impact a change in mental health and substance abuse services available to children. I hope mostly to heal from the trauma of this nightmare. I do support HB 522 for juveniles who are dealing with opioid addiction. It would be very helpful. Thank you.
Thank you. Questions, Delegate Arakan?
Thank you, Mr. Chair. Ms. Savage, thank you so much for sharing your story, and we're so sorry for the loss of your baby. There is really no words, but we appreciate you coming here and sharing her story, and just know that we'll be thinking about her as we work on this policy.
Thank you.
Yeah, Delegate Tavares. So we just had another bill you heard earlier about the transport thing. So is there any way that you could get us a list of the in-state and out-of-state programs that DJS uses? There's a lot of these bills dovetail with each other, so I just want to make sure that we are keeping track of where these kids are going, making sure where they're going are truly helping them so that they don't get out of these programs, if they can even get into them, still struggling without the help they really need.
Thank you for that question. It seems to me that the context under which those programs that were presented were like the scare them straight type programs that you saw on Jenny Jones back in the day. And the boot camp type programming. And that's not what I'm seeking. I'm seeking more of a, I don't want to make it sound out of order, but more of a bougie type.
Gotcha.
Environment.
Maybe more medical, clinical setting.
Exactly.
Gotcha.
Because where there are genuine resources to help the students grow, have group therapy sessions, individual therapy sessions, because, and we have similar events in similar facilities like Salvation Army in my county, but the issue is that they're all for 21 and older. So everyone who goes in has a role. And they have chores that they have to do. And in addition to whatever it is that the other therapy sessions that come with that, they have kind of religious component.
Interesting,
As
okay.
part of the 12-step process.
Okay, oh, yeah, that's right, yeah, yeah.
And that's the kind of situation I'm seeking.
Okay.
I mean, I have a full, like I said, it's a full comprehensive list. You can't just come in and just do one, because it has to be comprehensive, because if you're just sending them to detox and then back home,
totally ineffective.
This is what happens.
Absolutely.
Ms. Savage's situation.
Yeah.
In my situation, we've had kids go back within a week to a day,
Yeah.
back on the streets taking worse drugs. And
Yeah.
so we need to make sure that they're going from detox to rehab and to the next stage so that they can be set on a career path.
Yeah.
So I'm looking, after the rehab, I'm looking at schools like the Boys Home
Okay.
in Virginia,
Okay.
where class sizes are like 5
Yeah,
to a class.
Yeah.
And there's a similar school for girls.
yeah. Do any of these programs screen for neurodevelopmental issues? Because I feel like that may be playing an unspoken role here, that a lot of us, like many kids, are so underdiagnosed and undiagnosed with things that they end up self-medicating with drugs
Yeah.
because they have a legitimate medical issue.
Yeah, but I mean, each of these places have doctors on site that
Okay.
are supposed to,
Screen.
as a rehab facility, they need to have, not only that, especially for these kids, because it's a large liability issue. And that's why a lot of people here in the state are not touching it.
Right.
Right? But we need to engage with that, and then we need to make sure that I don't know, I'm more of a cold turkey, after they leave detox, cold turkey, get them clean, rather than transition them off on
Right.
Suboxone or other drugs that are equally addictive.
Right.
But that's just
Yeah, that's a really hard line to find. What works with what kid might not work with another. So, well, I appreciate you bringing the bill, and I appreciate Ms. Savage for sharing her daughter's story.
Yeah.
Delegate Boucher.
Thank you, Chairman. And buenas tardes and muchas gracias for bringing this bill forward.
Mi buen amigo.
This means a lot to me. On the 16th, it'll be the 8th anniversary since I lost my daughter. So I understand the pain of the witness and how important this is. While reading through the bill, I noticed it did not state addiction services or drug addiction. And then as I was reading through the financial impact, the state said that while the bill authorizes DJS to provide funding for rehabilitation services, it does not require DJS to do so. Furthermore, the bill does not define rehabilitation services. DJS advises that due to the lack of the detail in the bill, it cannot determine the impact on the population served. Is it necessary to amend the bill to include the language of drug addiction services?
It's been amended. The amendments are here. And the new language, the new sexy language for addiction is called substance use treatment and substance use disorder. So they're just changing the language. And what we included was that in the commission, that several of the members in your committee are part of, they're going to be including longitudinal studies to see how effective, like how long do they stay off? How, after 1, 3, 5 years, what are they doing? And I'm already in conversation, so we could come back next year and have set jobs available through the National Year Out program. So we have to continue on the building of the framework that I'm hopefully able to pass this year of the 6, 7 bills that we are putting forth this year, and see how we can build upon that.
Well, muchas gracias for recognizing that, and vayas con Dios.
Gracias. Que Dios me lo bendiga.
Seeing no further questions, we thank you very much. And that concludes the testimony on House Bill 522. Thank you.
Thank you.
Very much. Committee, we will be voting at 4:30. 15 minutes, we'll be voting 4:30. We're going to give the committee an opportunity to get ready for that. And so if you want to hang around, that's fine. But for those watching, we will see you in 15 minutes. Thank you.